ফাইলটা কি আছে দেখে নি। ফাইলটা আনানি,
Grateful, my lord.
হেডিং টু মেনশন আনান, আমি দেখে নেবো কি আছে।
Grateful, my lord.
From Port Blair, my lord, I may be allowed to make a mention, my lordship. My lord, there is an urgency. There is a Port Blair matter, my lord, which has been filed at Port Blair on the last day, 14th July. But since the last day, my lordship, the matter was simply posted to the next circuit. Lord, based on the eviction order, the Tahsildar office have come to demolish my building. I am having a building plan. I am the owner of the particular piece of land. Same order were passed thrice. Those 3 orders were set aside by the court. 4th time, same order was being passed without in contravention of the directives of the High Court. My lordship, I would be praying for interim order, my lord. I would pray, my lordship, the matter be listed in the list so that department can send the records to Calcutta, my lord. Because for mentioning, I cannot be in a position to come to Calcutta, my lord. Kindly appreciate, my lord.
That I understand, but now the circuit bench is functioning.
No, it's not there. Circuit bench is on 28th July, my lord. 14th was the last day. 14th was the last day. Writ was filed.
Why you have not mentioned before the available circuit bench even prior to 14th July?
Because the eviction order was passed on 13. It was served on 13 evening. Filed it, my lord. But last being the paucity of time, it could not be taken, my lord. Kindly appreciate. I'm just praying for inclusion so that the department can send the record, but both way, my lordship, by soft copy and hard copy, my lordship.
Which order you want to challenge?
Order of the Tahsildar, my lord. Order of the Tahsildar.
What order has been passed by him? Demolition order?
Yes, my lordship. In respect of my property, over which I am
Demolition order or eviction order?
Demolition as well as eviction, both. And same order were passed thrice. Those 3 orders were set aside. This court directed the Tahsildar to act in terms of certain mandate. In contrary to, my lordship, again the same stereotype order has been passed. I have a plan with me. I am the owner of the property, my lord.
When the order is going to be executed?
Yesterday, they have come and demolished the compound wall. Today, all men have gone to the spot, Tahsil office staff. My lordship, at any moment, they may demolish the building, RCC building. My lord would see the entire thing is, paper is here at the registry of Port Blair, my lordship. But kindly, my lord, direct the registry.
21st July fixed motion, under the heading motion.
It's WPA number 324 of 2025, my lordship. WPA number 32 of 25, Gangadin versus Andaman Nicobar Administration, my lordship.
WPA?
324 of 2025, my lord.
Note code. WPA 3421.
324, my lord.
WPA 324
of 2025, my lord.
324.
2025, my lord. 324 of 2025.
WPA 324 of 2025.
Gangadin versus Andaman Nicobar Administration and others, my lordship.
Gangadin and Andaman. You
Lordship.
send the slip. You send the mention slip.
I will send, my lordship. The department over here may be directed to send the records, my lordship. Because
Yes,
it's,
yes.
my lordship, kindly that direction may kindly be passed.
May I permit to mention as regard item number 77 of the
File
combined.
running in 21st July. It will appear on 21st July.
Records may be called for, my lordship, from Port Blair, my lordship.
Yes, I have told.
My lord, I'm grateful.
May I permit to mention, my lord, as regard item number 77 of monthly list, my lord. My lord, the only land of the petitioner, my lord, the BDO of Islampur block, my lord, is constructed over the land, my lord. That is, my lord, there is urgency, my lord. Though, my lord, he
Video is
purchased
already constructed.
No, my construction is going on, my lord.
What do you want?
My lord, stay, my lord, actually, my lord.
The motion or
Motion, my lord, motion. 77.
what type of construction is going on?
My lord, it is going on a video.
What type of construction?
My lord, it is, my lord, Sasta building, my lord.
Encroaching your land.
My lord, my lord.
July 21 করে রাখুন।
Good.
Your lordship.
77.
Under the heading motion. Fixed motion.
77.
Give the slip.
My lord.
Your lordship, I would request
Your
to
lordship.
in 3 matters. These were supposed to be listed. I have already mentioned once on 30th June, and the other party has been served. So if you could list this matter,
This under this which stage? Motion.
the new motion.
Give the slip. I shall.
Your lordship, if I may be permitted to mention a matter, for correction, your lordship has already passed the judgment and not in our favor. Just that it's been written residential. It should be commercial/residential come commercial. For that correction, your lordship, I mentioned in the matter. If your lordship, my learned junior friend is there with the slip, if your lordship could just fix it on any day, I'll give a notice also to the other side. So it's just a small correction, your lordship.
To be mentioned tomorrow. Give the slip.
Yes,
No,
I'm
what is that?
giving the slip. if it could be. I'll also give the notice. It will be
Will you
taken up
mention
tomorrow,
on-
Your Lordship.
To be mentioned tomorrow.
Grateful, Your Lordship.
All the list. My lord has already passed the order to submit report and the matter is directed to appear on 29th August. Then why it is under the heading to huh? কোন কি লোক নাম মিস হয়েছে তিনি কে তাকে তো মেনশন করতে হবে হ্যাঁ নেই সেই জন্য হ্যাঁ সেইটা নিয়ে নেই August 29 এ Who has mentioned? ও যেমন আছে যেমন আছে ওই তারিখে দিয়ে দিই A learned advocate has mentioned that his name has not been typed. My lord. But if he does not appear, how what can be done? My lord. Yes, call the next matter.
Lord, I don't know what room Lord I am for the petition. Lord, I undertake to file the affidavit.
My lord, I have instructions to appear on behalf of the alleged contemner. My lord, I have not yet received. He has served. My client has received it. Yet I have not yet received a copy of the content. But I believe, my lord, I believe that let him place it. I believe, my lord, contempt may not be maintainable.
You have received the copy of the
No,
contempt?
I have not. My client in the office has received it. It is a municipality. They have received it. It
Yes,
is
Mr.
received.
Ghosh, which order is thought to be
Lord, the
has not been complied with according to you?
my lord's order dated Lord the 21st day of May 2024. Lord, the kindly come to paragraph 12 of the my lord's order, internal page 4. I am showing Lord the how the my lord's order has been violated. Willful violation was there. Lord,
Page
the,
number 35. Running page 35. Internal page 4.
yes. Running page 35. Lord, the in view of such, while disposing of the instant writ petition of this court, court directs that the respondent, respondent number 4, the Board of Councillor of South Damda Municipality to consider the written notes of argument, which is available at page 33 to 37 of the supplementary affidavit as filed by the writ petitioner, as well as the annexure P S14, which has been available page 57 to 61 of the supplementary affidavit in light of the provision of the West Bengal Municipal Act, and to come a logical conclusion of such representation after giving the for giving further opportunity of hearing both the writ petitioner as well as the private respondent number 6 positively within a month from the date of the communication of this order, and to pass a recent order thereafter also within a month from the conclusion of the further hearing. Now, Lord, the kindly takes up the supplementary affidavit on last occasion I submitted before your lordship. The copy I have also given to my learned friends, clients.
That has been annexed with the contempt application.
Not the annex, but the supplementary affidavit separately filed on previous occasion.
In the writ.
No, Lord, in contempt proceeding. On previous occasion, Lord, on last day, Lord, I submitted, and my lord has taken it on record.
Yes.
Now, Lord, the statewide kindly come to page 14 of the supplementary affidavit.
Yes.
Lord, the order dated 13th September 2024. The matter is further placed today. The notice of hearing by memo number such and such was served upon the parties to appear before the Board of Councillors today.
It is in pursuance of my order.
lord's order.
Very good.
Both the parties are found present today. Now, the concerned SAE has already served a copy of the written notes of argument of the petitioner to the respondent via memo number such
What
and
is the
such.
full form of SAE?
Sub-assistant engineer.
The reply thereto submitted by the respondent has also been received by this office on such and such date. Then, my lord, the violation. Considering the written notes of the argument of the petitioner and the reply of the respondent, the Board of Councillor decides that the Board of Councillor is not in a position to decide the
Correct.
issue earlier of the 2023. Sorry, 2003. Now the following are observed for taking decision. With reference to the complaint filed by the petitioner, a proceeding has been initiated and hearing was concluded by this office on such and such, such and such, such and such, respectively. By an order dated, that is the order dated 16 January 2024, that is before passing the order of your lordship, passed by the Board of Councillor, and inspection was carried on 15 February 2024, that is before the order passed by your lordship. It appears from the said inspection report that building plan number 310 has been sanctioned on 3rd September 2003, further renewed on 3rd September 2006 and 21st February 2007 for the two-storied residential building in the name of the Prashanto Kumar Chandra in respect of the holding number such and such. The existing, kindly take note, the existing of the structure of the building is around 40 to 50 years. But I am putting this question to myself, is the building is 40 to 50 years old, how the building plan was sanctioned in the year 2003. And that was the specific case in the supplementary affidavit, what observed by your lordship in paragraph 12 of your lordship's order, that this is my case, blood first illegal construction was made, then blood the one after another representation was submitted by my client. Now that was not disposed of. Then blood the building plan was sanctioned, and this building plan, which was sanctioned after erection of the illegal construction, is illegal. And that is why the supplementary affidavit to the petitioner was filed, and my lord directed the Board of Councillor to consider my representation in that light, but they have not done so. And Board of Councillor says before the issue regarding the unauthorized construction prior to 2003, they cannot touch.
Hmm. এটা contempt
হ্যাঁ দাদা নেবেন
একবার দেখি একদিন নিয়ে নেব না। deal. ওটা কি সাপ্লিমেন্টারি?
সেটাও দিয়ে
কন্টেম্পটে?
দাদাকে এটা দিন না
ওটা কন্টেম্পটে সাপ্লিমেন্টারি?
না দাদা এটা হচ্ছে হ্যাঁ কন্টেম্পটের সাপ্লিমেন্টারি
এক সেকেন্ড এখানে নিয়ে ফেরত দিয়ে দিচ্ছি তোকে।
তোমার অর্ডারটাই অ্যানেক্স করতে
হুম,
হবে, ওটা
বুঝতে
জানো।
পেরেছি।
So, Mr. Ghosh, where is the infirmity in the order?
Infirmity, my lord, what my lord observed in paragraph 12,
No, they have passed a reasoned order.
not in accordance with the direction passed by your lordship.
Why?
My lord has, what my lord has observed, kindly see.
You have annexed as written notes of argument,
Yes,
which have been submitted with the municipality.
yes,
You have annexed a copy of the representation,
my lord,
which have been submitted with the municipality.
yes,
Your grievance was before this court that your representation has not been disposed of.
yes,
This court directed the municipality to pass a reasoned order after giving a chance of hearing.
not only the representation and also the, one of the grievance was that in the repetition, lord, the building plan which has been approved.
No. You have submitted before them supplement the written notes on argument. You have submitted before them a representation. Those have been annexed with the supplemented affidavit.
Yes,
This court directed to come to a logical conclusion on such representation after giving opportunity of being both to the petitioners, blah blah blah, and to pass a reasoned order. Reasoned order has been passed.
but the reason order, lord, the kindly see the what.
If you are not satisfied with the reasoned order, you challenge it. No. Ashok. The writ petitioner no, that's how I said. Substantially compressive. So it has become more strong.
Lordship.
For the petitioner, my lord.
Item number 3.
My lord, in similarly situated contempt application, my lord.
My lordship,
My lord,
yes.
my lord, they preferred one compliance report, whereby they are saying that they considered, but I am not eligible. But I argued before your lordship that similarly situated person preferred one writ application, and that division, honor division.
It is a KMC matter.
Yes,
KMC
KMC
matter.
matter. I have instructions to appear on behalf of the contempt and alleged contempt. My lord, on this similar content matter, lordship disposed of another contempt. There are 5 matters. Lordship kindly recollects. Last order was passed by lordship on 1st July. If
There are two pending matters, those two matters be listed and disposed of.
yes,
In
those
the
were
light-
disposed
in the
of.
light of their report.
Yes.
Ashok. The parties
Thereafter, they, my lord.
And on the last occasion, your lordship,
My lord.
your
I-
lordship
on last
said to Mr. Poddar that you save your energy for the next round of litigation. So, my lord,
It is not desirable.
let us just
If
come
one
back.
incumbent, my lord, got my
That has
attention, my
become,
lord.
yeah, I do agree. That has become the order of the day.
Deeply.
Grateful to your lordship. Much obliged.
Item number কতটা? 4. 4 তো আজকে নেই, 18/7 এ আগে। শো করেছেন কেন?
Number 5, my lord, I'm asked to pray for an accommodation on behalf of Mr. Dadiknath Mukherjee, my lord. He has not come today. Therefore, kindly make it not today.
Not this week. Not this week.
Number 6.
But I appear for the petition, my lord. But order passed by my lord is at page 16, my lord. But the
1/6.
1/6. But order arising out of contempt application arising out of the order dated 28th April 2025, my lord.
What is the operating part?
My lord, internal page, my lord, the 4, paragraph 12, my lord.
Response number 4 is directed to grant lease of 1 centimeter within. Oh, it is in respect of a pond.
Pond, my lord. That
Oh,
will be
yes, yes, I can
rejected.
recollect.
And our communication is
It has
that,
been communicated.
yes, my lord, page 21.
আসুন।
Number 7.
I am for the petition.
The state, my lord.
Which type is it? Yes. Please. এখানে আরেকটা বই ছিল, কি হলো? ওয়েস্ট বেঙ্গল লজে এরকম একটা বই ছিল না, ওইদিকে চলে গেছে দিন তো। তিনটে আছে। They have estimated the value of the land as on 8/6/1979.
Yes.
They have estimated the value because date of publication of 4/1A was 8/6/1979. Please come to page number 4 of their report, as you referred yesterday.
Yes.
Date of point number 5, sir.
Yes.
Date of publication in Calcutta Gazette under section
8/6/1979.
4/1A was made on 8/6/1979.
Yes.
Case was switched over to such and such. Very good. Estimated was prepared on 22/3/1998. But what is the 9(3)B of Act 1 of 1894 postulates that the date of publication of the notice under section 4/1A of Act 2 of 1948 would be the date of reference for the purpose of determination of value of such land under Act 1 of 1894. Now, according to you, that notice lapsed.
Yes.
So they have to start a fresh proceeding under 2013. Mr. Bottom.
Our case is that, my lord, the land, this is a land acquisition case of 1970 to 73, my lord. And thereafter, my lord, as per the under the Act 2 of 1948. And under this Act, my lord, everything, my lord, the publication has been done under section 4/1A on 8th of June 1979. Thereafter, my lord, possession has also been taken, my lord. Kindly note it. Possession has been taken on, my lord, kindly see paragraph 4 of page 4, my lord, of my report, 7/8/1973. And thereafter, we have, my lord, calculated the, my lord, compensation amount.
What about the compliance of 7A? What about the compliance of 7A? 7 capital A of Act 2 of 1948.
7.
The collector shall make an award under subsection 2 of section 7 within a period of 3 years from the date of publication of the notice in the official gazette under section 4/1A. And if such award is not made within the period, the said notice shall lapse. So you published on 4/1A, published on 8/6/79.
79. Thereafter, my lord,
Then you have to pass the award within 3 years. That is 80, 81, 82. You have not passed.
that could not be done. That is why we
So
have,
your notice lapsed.
so we have, my lord, switched
District
over
goes-
section 9(3)B, my lord, thereafter. And only, my lord, in this case, my lord, we could not pay the amount due to non-placement of fund by the requiring body.
No, that is a noted
My
ground.
lord, we shall, my lord, cite only 2 judgment. Kindly, my lord, kindly allow.
I cannot take any contrary to my own
Well,
judgment.
What will
You
be
get
happen
set
if,
aside.
my lord, possession
But
is
my lord,
taken and
Our submission be recorded. Milord.
Definitely I will record that.
Yes, Milord.
But I shall cite, my lord, only 2 judgment, my lord. Indoor development, my lord. Kindly, my lord. If the, my lord, possession is taken, if the, my lord, possession is taken and compensation could not be, my lord, paid, then what will be the consequences, my lord? May I place, my lord, paragraph? My lord, this is, my lord, Indoor Development Authority, my lord. Paragraph 366.3, my lord. Page 393.
Give me let me note the citation.
But citation is, my lord,
Citation of it,
2008,
volume 8, SCC 129.
Long judgment.
Volume, yes,
2028 SCC.
2020.
2020, volume 8, SCC starts from page 129.
129.
And it's completed as 395 page.
Para.
Paragraph, my lord, we are referring 393.
Page
Page-
393,
Page
Paragraph-
393.
paragraph 366.3.
Yes.
May I read, my lord? My lord, the word or used in section 24(2) between possession and compensation has to be read as nor or as and. The deemed lapse of land acquisition proceeding under section 24(2) of the 2013 Act takes place where due to inaction of authorities for 5 years or more prior to commencement of the said act, the possession of land has not been taken nor compensation has been paid. In other words, in case possession has been taken, compensation has not been paid, then there is no lapse, my lord.
Similarly, if compensation has been paid, possession has not been taken, then there is no lapse. In our case, my lord, we have taken possession, but my compensation could not be paid due to non-placement of fund by the recording body. And another judgment I am citing, my lord. This is my lord 2022 SCC online, SC 1059. But here in this judgment, my lord, this adopted the my lord, judgment passed by the Inter-Development Authority. The same line, my lord.
Does Indore Development Authority deal with the acquisition proceeding of Act 2 of 1948?
My lord, this case has been initiated under Act 2 of 1948. That we have to pay compensation under Act 1 of 1894.
Which paragraph is relevant, Mr. in the subsequent, Mr. Botobal?
I'm saying. May I read from paragraph 3, my lord? First page. Undisputed facts are that in the present case, the possession of the land in question was already taken over by the appropriate authority in the year 1987. It is also an admitted position that the subject land has been utilized way back in the year 1987 for a park of East Delhi Municipal Corporation. However, despite the above relying upon the relying upon the decision of this court in the case of Pune Municipal Corporation versus such and such, reported in such and such, and Sri Bajaj Nagar, Balaji Nagar Residential Association versus such and such, the High Court has declared that the acquisition proceeding in respect of the subject land has lapsed in terms of Section 24(2) of the Act 2013. In a subsequent decision, a constitutional bench of this court, in the case of Indore Development Authority versus Manohar Lal, has specifically overruled the decision of this court in the case of Pune Municipal Corporation and Sri Balaji Nagar Residential Association. In paragraph 366, it is observed and held as under 366. In view of the aforesaid discussion, we answered the question as under 366.1.
That has been quoted. That has been quoted.
Quoted, my lord. And not kindly see 366.3 that I have already submitted.
Yes, they have submitted.
But kindly see that 366.9, second page. May I read? Section 24(2) of the 2013 Act does not give rise to new cause of action to question the legality of concluded proceedings of land acquisition. Section 24 applies to a proceedings pending on the date of enforcement of the 2013 Act, that is 1/1/2004. It does not revive stale and time-barred claims and does not reopen concluded proceedings nor allow landowners to question the legality of mode of taking possession to reopen the proceedings or mode of deposit of compensation in the treasury instead of court to invalidate acquisition.
It's a case of 77 in our case.
The case is of 1970 to 73, this case.
They have filed a petition in the
And when they have filed the petition in their 2023, long back.
2013 বারটা পারবো।
Paragraph 5 heading.
Give me a second.
Yes.
Yes, sir.
Paragraph 5, my lord. In such a situation, no reliefs of lapse of acquisition proceeding can be counted in the case in view of the law laid down by this court in the case of Indore Development Authority Supra. Once it is held that there is no lapse of acquisition proceedings under Section 24(2) of the 2013 Act, the land which has stood vested with the appellant continues to do. Also, there is no question of payment of any compensation to the writ petitioner in respect of the suit land as per the Act 2013. However, the original writ petitioner shall be entitled to compensation under the Land Acquisition Act 1894 as per award number such and such, date is 86, as referred to by the High Court in paragraph 3 of the impugned judgment and order, or in the event any enhancement is sought by the original writ petitioner in accordance with law. In view of the next paragraph, in view of the above and for the reasons stated above, the impugned judgment and order passed by the Honorable High Court declaring that the acquisition proceeding in respect of the subject land has lapsed in terms of Section 24(2) of the Right to Fair Compensation Act 2013, directing the authorities to pay the compensation to the repetitioner in respect of the suit land as per Act 2013, deserves to be quashed and set aside, as is accordingly quashed and set aside. Consequently, the writ petition filed by the private respondents before the High Court stand dismissed. Present appeal is accordingly allowed. However, in the facts and circumstances of the case, there is an orders to quash. Therefore, my lord, if the my lord, we have taken the possession of the land, and my lord, we have also calculated the amount long back, and we have placed the before the my lord, requiring body. And only for due to non-placement of fund by the requiring body, we could not pay. Therefore, he is entitled to my lord pay, get compensation as per our calculation made earlier with my lord interest up to date. This is our submission. 6, 7, 8 are similar matter.
6, 7,
7 and 8.
Normal?
7, 8, 9 same.
6, 7 and 8.
6, 7 and 8 below. 9 times
6 is a contempt matter. First
7, 8,
dictated-
sorry, 7, 8 and 9.
7 and 8.
dates are same.
দেখে বলো,
Representation এই ফাইলটা আগের ফাইলটা দেখি
দেখে বলো।
আগের ফাইলটা দিন
ভুল ভাল হয়ে যাবে না।
পরেরটা দিন।
গন্ডগোল হয়ে যাবে এই এইটা দিন
না, না,
আরে ভাই 7টা দিন 8টা দিন আগে 7টা দিন একবার এটা লাগবে না এটা সরান Where is your representation?
representation মানে by mistake it was not annex malar. This is the representation malar. মানে earlier it is earlier he made by his father malar. Same representation malar. Kindly see malar. Same malar.
Nothing has been annexed.
No.
Huh?
Only for representation. Other all documents are annexed. All are same malar, same date. Only number is difference malar. Only number is different. Kindly come to malar page 19 malar. The date of the
20th January.
yes. Representation.
দেখি একবার দিন ওটা দিন 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 একটা লাইন লিখে দিন তো ভাই ওহ মহা বিপদে পড়া গেল 20th January.
Same repair. In earlier representation, it was annexed matter. By two brothers, my lord. One for mother,
আচ্ছা
one
লিখুন
for father.
at the time of hearing Mr. Mondol learning advocate
Page 23 is the annex representation, my lord.
Page number 23 হচ্ছে representation বলছে 23 and 24 25 23 to 25 representation এর date হচ্ছে 20 22 12 2022 ভাঁজ করে দিলাম পেজটা হ্যাঁ previous order
My lord, page 27 and 28, my lord.
previous order
Page 27, 28, my lord. Order dated 19 December 2022.
এই পেজ নাম্বার 20 হচ্ছে WBA 15373 of 2017 order date 19 12 2022
Here in this case, we have filed our affidavit in opposition.
Opposition.
And my lord, page 4 of my opposition, my lord, LA case number 86 of
এখানে
1973.
রিপোর্ট হবে না যেখানে রিপোর্ট হবে এখানে এফিডেভিট ইন অপোজিশন হয়ে যাবে হোয়াট ইজ ইউর এফিডেভিট ইন অপোজিশন
But I have filed.
I'll get
Oh, no, no, my lord. Opposition is with me.
তাহলে তো ওটা লিখে রাখো পড়ে দাও এফিডেভিট ইন অপোজিশন and the affidavit reply as filed today on behalf of the respondent number 3, 5 and 9 and the petitioner respectively are taken on record.
Page 4 of my lord. Page 4.
Page
Page 5, my lord, it is also a page. Page 5, paragraph, my lord, Roman 3.
Case number 86 of 1973, 74.
যদি এইটা page 5 Roman 3 তে affidavit in opposition. Anything more?
And imping order, my lord, imping order.
Date is not different.
Date is, my lord, here, my lord, date is different. my lord.
ইনপুট অর্ডারের ডেটটাও দেখে নিতে হবে ভাই আগেরটা
Again, same, my lord.
সেম
15th of
Earlier, same,
February.
my lord. Here, my lord, 15.
ইয়ার
February
15 12 15 2
15 to 2024, my lord.
এখানে 15 to 2024
Yes, my lord.
দেখে শুনে করো ভাই এই যে এখানে ভাঁজ করে দিতে হবে
Here, my lord, one respondent is changed. My lord, respond instead of 5, it will be 9.
respondent number 5 will be
Here, my lord,
respondent number 9
special land acquisition officer, Jharkhand.
respondent number 9 করে দেবে 5 টা Well,
No, anyway.
It's the second round of litigation. my lord. Here is the first round of litigation.
My lord, thank you. Today, my lord, we could not trace the brief, my lord.
এই not
Can
today.
make it not today?
Your lordship, they are on the verge of.
Monday
Kindly pass the order, your lordship, because it cannot retain the position, your lordship, because they are on the medical slip. I have attached the photograph where they are.
হ্যাঁ গো এটা নেমে যাবে নাকি করুন বাবু if it is If it goes down, means that I will take it on the top.
If they cannot find the brief, I'll serve a copy to them.
একটা দিলে
All documents have been annexed. Huh?
Yes, my lord.
All documents have been, and you have identified your clients. No misconception.
But Mr. Galib appeared for the state.
Where is he? Mr. Galib and Tomal Toru Panda.
And I have to added, my lord, one respondent that was not, I made not party. West Bengal Mineral Development and Trading Corporation.
Mr. Saha's client.
Yes, and I am not.
Leave is granted.
And sub copy.
Leave is granted to the learned advocate for the writ petitioner to add
First, take up item numbers 14 and 15 because I will do in a cluster way. 14 and 15 are identical case. Exactly. So if your lordship takes up 14 ones, all are analogous.
who's your other side?
Lordship, in 13 I am appearing.
14 and 15 minutes.
12টা কি 12 থেকে
বড় পড়ে গেল
আগে
আগে বড় কেন নয়
হ্যাঁ
লাকি নাম্বার ফর্ম দ্যাটস ওয়াই 13 জন
13টা করো 13টা কি
item number 14 once.
Manushi Samanto.
Manushi Samanto, yes.
Give me a second. Report is ready, Mr. Bandhavadar?
Yes. 13. This is
No. Wait, 14, 14. You wait for your turn, madam.
Lordship.
রিপোর্টের কপি দাও
আমার কাছে একটাই কপি আছে অলরেডি
না আমাদের দাও না 13 আমার 13 13টা হচ্ছে না এটা 12 হচ্ছে 14 হচ্ছে বলছি give me a second.
চলে যায়
Yes, sir.
The Thele case, the Act of 1948 that was initiated. Plot number 333 and 334.
Plot number 333 and 334.
giving your lordship the LR plot number. This is corresponding to RS plot number 304 and 305.
Very good. Paragraph 3.
Yes. Admittedly, from the report
Yes.
submitted by the state respondent, it will be demonstrated that a requisition of this particular plot of land was being made by publication of notification under section 3(1) of the Act 2 of 1948.
When it was published, sir,
It was published
as per their report.
That they have not given. They have not
Very good. Be that as it may.
given. Yes, they have not given that.
You have not also stated in your writ petition.
But I will rely upon two documents.
Very good.
Admittedly, no section 4, no award.
No section 4.
No section 4, no award. Because the law is very clear. Just I am placing. Section 3 gives power to the state under Act.
Yes.
Requisition of any plot. This is an initiation of acquisition proceeding. So section 3 gives power that a proceeding can be initiated.
Just wait. Move.
Section 3 gives power to the state government. When it starts with, if the state government is of the opinion that it is necessary so to do for maintaining supplies and service essential to the life of the community or for the employment of the opportunities for the people by establishing commercial estate and industrial estates in such areas, or for providing proper facilities for transport, communication, education, or development, or for the creation of better living condition in rural or urban areas not being an industrial or such areas excluded by the state government by notification by the construction or reconstruction of dwelling places in such areas, or for the purpose concerned where with the incidental where to the state government may by order in writing requisition any land and may make such further order as appears to be necessary or expedient in connection with the requisitioning. So this section 3(1) is a power given to the government for the emergent situation of a public purpose, we can requisition. Now kindly takes up section 4(1), where any land has been requisitioned under section 3, the state government may use, use or deal with such land for any of the purposes referred to in subsection 1 of section 3 as may appear to be expedient. The state government may acquire any land requisition under subsection 3 by publishing a notice in the official gazette that such land is required for the public purpose referred to in subsection 1 of section 3. The initial stages of requisition, if ultimately the government found no, it's necessary, so ultimately gazette notification as per section 4 subsection 2. Thereafter, your lordship, I am not troubling. Section 5 is for notice to the interested person.
So with the publication of 4(1) a notice, vesting completes.
Vesting complete. Now, kindly takes up section 7. The different modalities have been prescribed under Act 2. How the compensation is to be paid. There, your lordship knows for emergent situation, they may pay an ad hoc compensation and take the land. Possession can be taken. Kindly takes up now section 7 capital. It's important. Because this has two links. I will argue not only to that. Section 7 capital A, award by collector. the collector shall make an award under subsection 2 of section 7 within a period of 3 years from the date of publication of the notice in the official gazette under subsection 1A of section 4 referred to in the said notice, and if such award is not made within the period as aforesaid, the said notice shall lapse. So, we have first section 3, then section 4A, publication of notification, we have the acquisition complete. 7A gives an embargo that yes, though the acquisition is complete, but you have to pay compensation within the time as prescribed under subsection 1, otherwise that notice will lapse automatically by operation of it. Kindly takes up the proviso also, it has an implication, provided that in case where the said notice has been published more than 2 years before commencement of the West Bengal Land Requisition and Acquisition Amendment Act 1994, the award shall be made within a period of 1 year from the date of commencement of this act. So another window is given to the government. Very well, if it is after prior to coming into force of this amendment act,
you will get a 1 year.
Now, Miller kindly takes up that in my case that I have annexed 2 of the document. First, your lordship takes up that I will give your lordship the entirety of the background letter. Kindly takes up once, page 58 of my lordship.
Page number 50.
No, 58, 58. Oh, 91. No, there are 2 pages. 91 of my lordship. I will just place 2 of the communication and thereafter I will take your lordship to the report filed by this state.
Yes, sir.
This is a communication my lord would get from the Special Land Acquisition Officer Howrah to the Assistant Engineer Amta Highway Subdivision. Because in the meantime, I have been served with a notice that I am occupying a land which belongs to the PW. Because the acquisition took place as per se. Now, what is the communication? Apropos, subject to the reference, it is stated that the possession in respect of CS plot number, I have given the LR and CS to your lordship, 304 and 307, along with so many other plots of Moja such and such, handed over to SAE Amta construction of subdivision on such and such, with the purview of West Bengal Land Requisition and Acquisition Act of 1948 for construction of Amta Jhikira Road as per LA case number such and such. But possession certificate in respect of CS plot number such and such, copy of publication of gazette notification of 41 capital A of that act and award statement are not available in this record. So,
give me a second, sir.
So, as per this communication, what we can gather that the Special Land Acquisition Officer is writing that yes, acquisition proceeding has been initiated. Since it is an emergent provision under 1948, possession certificate has been handed over to the requiring authority.
No, possession was given.
Possession was given.
But possession certificate is not available.
Possession certificate not available. 4A notification, gazette notification
is not available.
And also, the publication of award list that is also not available. As per this, kindly now takes up another communication under the Right to Information Act, that is at page 153 of my lordship. I will tally it to their reports.
একটু ফ্ল্যাগ কোন ফ্ল্যাগ গুলো একটু দিন না ভাই ওইদিকে চলে গেছে আচ্ছা yes
my little gate 153 that This is information provided under the Right to Information Act. The subject is information in respect of acquisition of land appertaining to RS plot number 20304, 305, 307. Has your lordship got it, Milord?
Yes.
I'm not traveling regarding that part again. Kindly now takes up the contents. In connection with this RTI application received by this office bearing docket number such and such, dated such and such, this is to inform you that such and such acre and such and such of the acres have been mentioned respectively in RS plot number 304, 305 and 307 Moja such and such was involved in LA case number Act 2 of 62-63, but payment of compensation was not made. So first,
what they want to oust you.
I'm coming back. Kindly now takes up their report. I will rely on the report submitted by the state.
What they say, their possession has been taken, you go. That is your case.
Exactly. Now, your lordship have experience in taking up this land. My land, I say, if it is a public purpose, the act gone. It cannot be revised. Act 1 also gone. So today, without and they have taken
you are still in possession.
They have taken because the Act 10, the Section 10 proceeding has been initiated by the competent authority against me, passed an order of eviction. So I am in possession, that's why I passed an order of eviction. I have gone to the district magistrate by way of statutory appeal. The district magistrate has stayed my eviction. So I will show that also.
Very good. You place your case.
Yes, kindly takes up now.
Out of my little experience, I have come to the point that.
Absolutely right. But one interesting point they have taken in their report that since my part, original owner.
রিপোর্ট দিয়েছেন এখানে করে নেবো এইটা রিপোর্ট নাকি এইটা নাকি yes I got it.
But my husband was the owner of the property, no dispute. My husband's name is Bulganin Shamanto. He, my lord, gifted property, the subject matter of the property in my favor in the year 2022. Very interestingly, they have taken a point to camouflage before this honorable court, since I am a post-vesting transfer, so I don't have any right. So if that is their plea, first they have to establish that there is a
no. If 441 is not complied with,
I requesting your lordship to take up the matter first 12, item number 12. Why is jumping my lord 12 to 14 first? Let it be first. 12, let me place. No, Mr.
It is his case.
This is not correct.
No, it is. I will not lie.
Well, all the three matters are similar.
I'm addressing before
12 to 14 million is
no, it's all right. It will take it up. No issue.
The report suggests that I am a post-vesting transfer.
It's trying to camouflage in the court.
So you will clear that. No issue.
So, I don't have any right. So, my little submission before your lordship.
No, where is your averment to that event pleadings?
Kindly takes up paragraph 3 and paragraph 4. Not paragraph 3, but paragraph 2 at page 5.
Will you kindly place, sir?
Yes, the said property originally belongs to one Bulgarin Shamanto, the husband of the petitioner, thereafter pursuant to the guilty executed in favor of the petitioner by the husband of the petitioner's name, Bulgarin Shamanto, in the year 2022, being deed number such and such, registered before the such and such, the petitioner became the sole owner and occupier of such and such property mentioned. I have given. So according to them, since the transfer took place by way of gift sometime in the year 2022, so I am a post-vesting transfer. So they will have to first demonstrate before your lordship that there is a proper legal vesting.
According to you, since no section 4, no vesting.
Had it been a case of section 4, 7A, then also it gone. Because admittedly under right to information.
Because notice lapsed. Notice lapsed means vesting lapsed.
So there is no question of any valid vesting. If it is no valid vesting, then my right or me to be treated as a post-vesting transfer does not arise. But we know all that if it is a valid vesting, after that, that person whose property has been vested does not have any right to transfer the property to anyone. So if there had been a valid vesting during prior to the transfer of Bulgarin, my husband, so there is no question of my right to be established before the court. But since there is no vesting, so that is not. Kindly now takes up once.
So your contention is that since there was no vesting, the right, title and interest of the my husband remains intact. So he has a right to transfer. So your right is always your right is also protected.
Kindly takes up page 4 of their report. May I tally whether I am correct or not? Because I have shown from the writ petition whatever document I have annexed, what they have stated. Only 4 paragraphs, I will read. Page 4 of the report, paragraph number 2. From the available office record, it appears that on receipt of the requisition from the executive engineer, Howrah Division, Howrah Highway Division, and land acquisition case being number such and such, was initiated from construction of Amta Jitira such and such. Next, accordingly, 9.48 acres of land in Mouja such and such, including the suit land, was requisitioned under section 1A, small a of section 3 of the West Bengal Requisition and Acquisition Act 1948 by the collector, Howrah, for the project for extension of land, of extension of road. Next is very important because thereafter the possession of the entire suit land of such and such of CH Mouja such and such was taken over and handed over to the entrusted official of PWB on such and such, along with several other plots of Mouja Rautara for the project of construction of such and such to a proceeding being number such and such. And since then, the land is absolutely at their disposal. So no case made out in their report about publication of notice under section 4.
But they have annexed a copy of the possession certificate.
Yes, I'm coming to that. Now we have kindly takes up paragraph 5. For perusal of the writ petition, it appears that the petitioner Manoshi Samanto purchased, it's wrong, gift that should have been, the suit land, with a registered deed of such and such only after long 52 years from the date of handing over possession of the land to the requiring body. She purchased the land from Bulgarin Samanto such and such, received 3(1)A notice under LA Act of such and such. Hence, the present petitioner may be considered as a post-acquisition purchaser of the suit land, having no right, title, and ownership over the land.
I believe you have an objection upon the post-acquisition. It may be post-requisition, this much.
Post-requisition and acquisition has a different
notation.
Together under the Act. So a land which has never been acquired, no publication of notification under 4A, 4(1)A. No question of vesting, no question of.
In the present reason may be considered post-acquisition purchase of the land, having no right, title, ownership over the land.
This is the stand of this case. Now, kindly take some, your lordship knows. Even if the possession is being handed over, in the present case, it's not, other cases are. I will show. But the law is, if you are, because under the Land Acquisition Act, your lordship kindly remember, there is a provision in Land Acquisition Manual that if you are occupying a property in respect of which a vesting process has not, or the acquisition process has not been completed, or it becomes lapsed, then your occupation becomes illegal and you are even liable to pay for rent compensation along with for acquisition whatsoever I am entitled. So the lawmaker has think about a situation that even if the state takes over a possession of land without making a valid acquisition process, then what should be the eventuality? Then the state authority is duty bound to pay whatever acquisition amount or the other components which I am entitled to. Apart from that, the period within which the state authorities were in illegal possession for rent compensation of that also. So it is not the case that even if I have taken over your possession, so your right goes. And your lordship knows now, division bench of this honorable court has made it clear, this right to property is akin to the fundamental right. No question of limitation arises. Now, in my case, kindly now, why not I will answer Mr. Bandyopadhyay's query now. Why 14? I have taken up requested your lordship taken up first. So kindly now takes up page in my petition, page 81. I approached the coordinate bench lot and the earlier round of.
Yes.
Page 81, is the order passed wherein your lordship will get this honorable court, the coordinate bench of your lordship's court directed my representation to be considered. My representation is of 16th of April 2024.
What is that representation?
Yes, immediately I take your lordship to page 79.
It was dated
It was dated
16/4/24.
24 as mentioned in the order also of the coordinate bench.
Yes.
Page 18, I will not trouble your lordship entirely. Page 80, last, first paragraph, last.
No, I'm sorry, I've noted. Page number, what is your representation, sir?
79.
Yes, sir.
Page 80, last 8 line from the bottom of the first paragraph, because the sum and substance I stated in my representation that you are now going to evict me because now of the project work are going to be start. They have declared some bus stop and something to be constructed over that land. I say I am not standing in the way of public project. But sir, if you want to take my property,
you initiate a proceeding.
You have to initiate a valid proceeding. That is the sum and substance of my prayer, which was directed to be considered by the coordinate bench of your lordship's court. I have shown before your lordship. So if your lordship now takes up page 83. In the meantime, Lord, I have been served with. Lord, kindly takes up page 83. First name your lordship will get the writ petitioner name.
Oh, they have started 10-1 proceeding.
Yes, that's why they are admitting that I am in possession. And why the 10-1 notice, Lord, I shall show before your lordship. This is that as if I am, Lord, staying in a property of the PWD, then, Lord, the assistant engineer of the PWD roads under the Act, Lord.
Please spare me for. So they have initiated a 10-1 proceeding.
He was placing
Eviction order has been passed.
show before your lordship. This 10 notice is being served, holding that you are occupying a government land.
Very good. Then what happened?
Yes, kindly takes up now my second writ petition. But I have disclosed everything. I must be point out before your lordship. 85, page 85 is my second writ petition.
85 is your?
But page 83, I have placed the 10-1 notice.
Oh, I see.
Thereafter, got page
Earlier round of litigation.
Yes. The second round of litigation got initiated by my client.
Challenging the 10-1 notice.
Yes, since below this honorable court directed that first you consider his representation whether his property has been acquired while you are making construction. That is the first round of litigation. Justice Kant's order I have shown before your lordship. Without deciding that aspect, they have given me 10-1.
Give me a second.
May I just provide the dates below? My representation was 15th of April 2024.
Order was passed on 20th June 2024. I have already noted, sir.
Yes. And this notice is of 14th of August 2024. Without disposing of my representation, which was directed by the coordinate bench, they issued 10-1.
So by that time, your representation was not disposed of.
That I ventilated my demands. Page 85 in my second writ petition.
Yes.
This writ petition was not being entertained by the coordinate bench of this honorable court where I 10-1 notice challenge, my lord. Because
it was dismissed.
Why, my lord? Because
it was dismissed.
Yes, because I could not able to demonstrate that the coordinate bench directed that the order has to be communicated. From the date of communication, this is to be done. But in the writ petition, no material was being disclosed that the order of Justice Kant was being served to them. So on that score, the writ court said no. Since you have not complied with the earlier order, have not been served to the authority, you could not able to demonstrate that. So no right can be given. Now, my lord kindly takes up.
You have not annexed that document?
No, in that writ petition. That the order of Justice Kant was served. So it is not within their knowledge.
Not even by a supplementary affidavit.
No. That whatever done, my lord, I cannot.
Very good.
Now, my lord,
What has been done, that cannot be undone.
Yes, that cannot be undone. Page 95 kindly now takes up. Page 95 is ultimately 10-2 order passed, directing my eviction.
By the SGO.
By the SGO, if that is the authority. This order.
Give me a second.
18th of November 2024.
Eviction order has been passed.
Yes. Page 90.
Take immediate steps for recovery of poison and removal of encroachment.
Yes.
You preferred appeal under 10-4.
What happened? Page 117, I filed the third writ petition.
Without filing appeal.
This honorable court ultimately condoned the delay, directed me to go and file statutory appeal. But I must disclose that page 117 is the third writ petition on the instance of my client, wherein the coordinate bench of your lordship's court ultimately page 119, second paragraph. Page 119, second paragraph, your lordship will get that liberty was granted, some time limit was given so that I can prefer the statutory appeal, and direction was there to the appellate authority to docket my appeal and to pass necessary order to that effect.
If the petitioner files appeal, the same shall have to be registered on the same day. The divided take out necessary interlocutor in the appeal, registered on the same day, and shall be heard so that the appeal. Delay was not condoned, I believe.
Thereafter, I filed a delay. Yes,
Be that as it. Forget that.
Yes.
So you are by virtue of that liberty, you prepared an appeal.
Yes, I preferred an appeal. The order is at page 150.
10-4 appeal.
10-4.
150
is an order of the district magistrate, appellate authority.
Page 150.
As your lordship got me?
Yes, got it.
This is an order dated 26th of December 2024.
Yes, then what happened?
District Magistrate, Appellate Authority, kindly see the second paragraph of that memorandum. In view of the above, you are requested, that is not the assistant engineer,
not to proceed with the demolition till disposal of the appeal hearing.
Yes. So this is the situation standing as on today.
Appeal is still pending.
Appeal is still pending. Stay order is subsisting. So I am in possession. Admitted. Now, I approach before this honorable court by present petition, inter alia seeking that the state authority cannot ask for any right to be implemented pursuant to a lapse proceeding. Kindly take up my prayers. Mr. Bandopadhyay said that he could not able to gather anything from the prayer. But may I just indicate prayer A, if your lordship takes up page 28 of my lordship.
Yes, sir.
So, my case is based on, I may say, apart from whatever I disclose in my petition, is from their own report submitted before your lordship by of an affidavit. If this report demonstrates before your lordship a proceeding initiated for requisition, not even acquisition under 4.1a, which even if that, not for the sake of argument, initiated, published 4.1a, when they themselves stated no compensation in the report, so it itself lapses under 7A of the Act 2 of 1948. So they cannot carry a dead proceeding, in the year
7A contemplates publication of the award.
So,
but you say that 4.1A has not been complied.
Not me, it is the report which suggests. The report is before your lordship by way of an affidavit by the state, which demonstrate only 3.1a. And a plea.
So your settled position is based on your right, perfect right title interest.
Yes, which may have been clouded by 3.1a, but not publication of 4.1a, that goes. And
no, by virtue of publication of 4.1a, only then the vesting is complete.
Yes.
That is the legal proposition.
Absolutely, I bow down. That is the proposition. And even if that is there,
which is why I have taken my judgment, this judgment. I have
your lordship has dealt with this. And regarding
probably have gone through it.
Yes, but I have gone through. But your lordship in Act 2 proceeding extensively dealt with. There was a concept in the initial stage when the Act 2013 came in, which gives a window to only protect those proceedings which was alive in Act 1.
Yes.
So there is no question.
In the previous matter, I have also dealt with.
Exactly, I was there, that exactly similar question. So according to me, as per their own document, this has to go. And why, I stated item number 14 and 15 are identical. Wherein, the same thing happened. Exactly.
Very good. Yes, Mr. Bandopadhyay.
Engaged another court, my lord.
You place the
only thing, my lord, in this report, my lord, we have not stated anything about 4.1a. That does not mean that the 4.1a notice has not been published, my lord. If you lord say, my lord, director has to file evidence, we shall disclose all the, my lord, papers. Number one. And number two, my lord, They have come, they are the post-acquisition purchaser, my lord. It is admitted, my lord. They have purchased the land or gifted, my lord, in the year, my lord, 22, my lord. And, my lord, it is a land acquisition case, my lord, initiated in the year, my lord, 1962-63. And now they are coming after 52 years. It's a long, my lord, delay. That should be taken into account.
No,
my
Mr. Botobel, in your in page number 4 of your report, where you have stated regarding 4.1a.
Nothing has been stated. That
Then-
is why I'm praying before your lordship. Kindly allow us.
Why,
to find the-
why? You ought to have been,
Report is of everything is not disclosed in this report.
why? You ought to have been.
That is
It is a specific case of them.
2-page, my lord,
It has
report.
been served. No, I will not grant you time now at this moment. Sorry.
Whether my lord 4.1 has been published or not, that
You cannot improve your case, sir.
but nothing has been mentioned in the report. That is why I'm, my lord, submitting before your
Not
lordship.
only report, RTI information they have provided page 153, they categorically stated that in the writ petition. That is also there, my lord, SPIO of additional LAO, General Calcutta. Howrah.
We have annexed the possession certificate, my lord, page 6 is the possession
No,
certificate.
possession can be taken on the by virtue of requisition.
Yes, ma'am.
Absolutely.
Yes.
It is an emergent act. No, it is not an unusual act. It is an unusual act. It is a because of an emergent act, emergent proceeding, you can acquire.
Yes.
You have
Independence. After independence, it required.
if it is not dealt with, it cannot be.
I have to take my instruction because my lord.
What instruction you will get?
Yes, report, my lord.
You ought to have tell this. No, I will not grant any more time, sir. I have heard it extensively, and you are saying that I will take instruction. Sorry.
No, nothing has been mentioned in the report about.
So that you will suffer.
But they are coming after 52 years. That point should have been considered. After
They have a
52 years.
justification because you have initiated proceeding under 10.1, 10.2, 10, the 10.3.
That is recently, that step has been taken recently. But
No, sir.
land acquisition case of 1962-63.
No, sir. It cannot be.
They have no right
Post-
to challenge the
No,
land
sir.
acquisition case.
Hence the present petition may be considered as a post-acquisition person. Where is the acquisition? I want that document of acquisition. Take down.
But whether they can raise this question, my lord, after purchasing the same, after acquisition, after requisition.
This point, my lord, is being dealt with by the Honorable Judicial Bench. I know every time they will take this plea.
Very good.
Kindly take, sir. This is
Not required, sir.
yes, I know. Your lordship has read.
You have filed it today.
Yes.
The
এটা দাও হোটেল Yes, yes. বার করে দিতে হবে।
Item number 12.
বার করো কোথায় লাগাবো তো? এখানে পেলে কোথায় তুমি? 9 নম্বর পাতা কোথায় এখানে?
রিপোর্ট দিয়েছেন ওনারা?
আমাদের কপিটা তো ওখানে নেই।
That has not been served also. The report which has been served,
আমার মাইলটের কপিটাও লাগানো নেই কিন্তু আমার রিপোর্টে আছে। Well, I'm sorry, Millard, in your Millard copy, Millard, it has not been managed, but in our copy.
Give it to me, give it to me. I'll record it.
হ্যাঁ দেখছি দাঁড়া আমার যদি এক্সট্রা কপি থাকে এই যে আর আছে দেখো তো থাকবে দাও দেখছি সব দিয়ে দিচ্ছি আছে 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 ধরো নেন এই যে নাই
We are concerned with plot number.
land acquisition case number is same. What number is
No, no, plot number is required.
309.
It is there.
May I check?
yes Millard there page 10.
It is 04 305. There is a draft notice. Where is the publication of notice?
The draft notice.
You have to show the gazette notice. Then,
Gadget is not
the draft notice আমি বাড়িতে ড্রাফট করে রাখলাম রিড ফিট লিখে রাখলাম ফাইল করলাম না কি হবে
gadget is not there.
দেন আসুন 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 আসুন
13টা আগে দিয়ে দিয়েছি।
I'm extremely grateful.
এটা 13
Please, my lord.
বলুন।
দেখে খুঁজে দাও, কারণে পাবেই না পরে আর।
Who is for the petitioner? এই আসেনি এয়ারকোর্ট?
না আছে। I am for the workman, your lord.
খুলে নেবো এয়ারকোর্ট কই? ওহো, 15 বাজে তো। Wait for some time.
Some pass over, your lordship.
No, I'll pass. My aircode has not come.
My senior,
You are for the state.
I am senior Mr. Dotto will come. Just a bit.
You are on behalf of whom?
I am for the workman. My senior counsel, Mr. Dotto.
Workman are the respondents.
Respondent, workman respondent.
Petitioner is not present, no?
Not present.
ধরে কি করবো আমি? আপনার এ না হলে বলুন। দেখেন, none appears on behalf of the lead petitioner. None appears on behalf of the lead petitioner.
Severely injured because the ligament has already broken, which admitted in the hospital. Duties have been free for the 3 weeks.
As per request made on behalf of the whose application? Can 1, can 2, and can 3. The petitioners are, the parties are not represented. For ends of justice, this court is not inclined to 59.
আমি প্রাইভেট রেসপন্ডেন্ট অ্যাড পার্টি হিসেবে আমি আবেদন করেছিলাম।
সঠিকভাবে ড্রেস করে আসবে আপনাকে এটা পরে ড্রেস আছে জামা বুঝি জামা শার্ট যাকে বলে পুরাটা শার্ট পরে আসবে তবে আপনাকে অ্যাপিয়ার করতে
পরবর্তী দিনে আসবো,
ছেড়ে গেলে জায়গা
পরবর্তী দিনে আসবো।
গোল গোল টি-শার্ট পরে আপনি চলে আসবেন।
মৌরিগ্রাম, হাওড়া ডিস্ট্রিক্ট। মাধ্যমিক অবধি।
থাকবে প্রপার ড্রেসে আসবে জিন্স পরে এসেছে
না,
পরে এসেছে
কালকে আমি ঠিক, কালকে আমি আসবো ঠিকভাবে।
কি বানিয়ে করে
আজকে আমি আসলাম
কালকে থাকবে, কালকে থাকবে। ও 58 তো হয়ে গেছে। চব্বিশ তারিখ।
take some water.
No, that's fine.
She's feeling uncomfortable. I appear for the respondent came there.
This is my affidavit in reply. দুটি এডিএ এর ফুল ফর্ম
সে ম্যাডাম কোথায় গেলেন
প্রশ্নটা পাঠালে
Area development. My lord, my affidavit in opposition.
yes madam what have you got to say give the bottle back what have you got to say
I filed this matter for restoration.
I understand since you are not present I have adjourned the matter on the 24th
Can I move it?
no not now
There was a small urgency that the railway authority.
very good একটা কাজ করো ওটাকে আজকে ওটাকে কেটে just make it not today come tomorrow I have passed an order for fixing a date on 24th your junior is basic I'm fixing it on tomorrow not today only yes sir Mr. Talukdar
Well, my opposition.
hey Mr. Talukdar থেকে নাও ওটা
Lordship, the petition,
give me a second ma'am I'm not so fast like you sir Yes, ma'am.
Predecessor in interest of your petitioners were Lordship land users. Their land were acquired by the then Kolkata KMDA Lordship for the Vaishnav Ghata Patuli area development. Now, Lordship, at that time, my predecessors, Lordship, they were awarded compensation. But at the same time, Lordship, they also applied, Lordship, for giving a plot of land. Now, Lordship, that...
It is a homestead.
Yes, Lordship. So, Lordship, that application, Lordship, they did not consider until date, Lordship, that is pending. Whereas, Lordship, one of my co-sharers, they have been allotted, Lordship, plot. So, Lordship, for that, Lordship, we have come up before your Lordship. Now, Lordship...
Is there a scheme for that?
Lordship, but we don't have. If my learned senior friend, Lordship, supplies me a copy, Lordship, I shall be grateful. We could not get hold of it. But, Lordship, one of my...
On what basis land has been acquired and you have been given compensation?
Yes.
Then what is the basis for your claim?
Lordship, my other co-sharers, they were, Lordship, given land.
On what basis?
That they let them say, because Lordship kindly takes up my reply, Lordship, I have annexed the entire document.
No, that your co-sharer has got the land. Where from will get that?
Yes, Lordship kindly see, I have produced everything, Lordship, the deed also. Lordship will kindly come to page 10, Lordship, of my reply.
Yes.
Lordship, to Srimati Pushpa Chaudhuri, Lordship. Subject allotment of plot, Vaishnav Ghata Patuli area development project. We refer to your application dated such and such for allotment of plot which has been duly accepted and registered under such and such. You are now requested to carefully note the following terms and conditions. So this was, Lordship, the acceptance, allotment. Thereafter, Lordship will kindly see 3 pages after, Lordship. That is the property tax of the Kolkata Municipal Corporation. Here, Lordship, the KMDA is the lessor and Srimati Pushpa Chaudhuri, she is the lessee. And the next page, Lordship, that is the deed.
Deed is at page number?
Then the very next page, Lordship.
11.
Yes.
No.
Lordship,
Page number
just after the bill. Because Lordship, my copy is not paginated.
Page number 13.
13.
And page number 14.
14, yes. Yes. Lordship, 14. Srimati Pushpa Chaudhuri and Sri Subrata Kumar Chaudhuri.
The recital of the lease deed does not say it has been lease has been granted in lieu of acquisition of land.
No, but Lordship kindly sees the first allotment, Lordship.
In consideration of the purpose for which the plot hereinafter referred to such and such is required by the lessee in consideration of the annual rent. I'm sorry, whereas the lessee has applied to the CMDA for a lease of plot of land in the Vaishnav Ghata particular area, development by mention and describe the schedule hereunder. And whereas to enable the lessee to erect a house and building thereon for use of residential, authority has agreed with the lessee to grant a lease. So you are the lead petitioner, you are the carriage of proceeding with you. Yes. So on what basis you want the land?
Yes, Lordship. So we have also, Lordship, applied similarly. If Lordship kindly takes up now my writ petition, Lordship. Page, Lordship, 29. Lordship, way back in 1982, Lordship, my predecessor in interest has given, Lordship, this letter. Lordship has got it, page 29 of my writ petition. Let me read it out for you, Lordship. This is my predecessor in interest, Horendra Kumar Chaudhary. He is writing to the Deputy Secretary, Estate of CMDA. I have to inform that I have been affected in the land acquisition case number such and such of Vaishnavghata Patuli housing scheme being such and such, being one of the co-sharers of plot number such and such. Acquire award serial number 191 and 173 respectively. I have applied for a plot of land in your above project, but unfortunately was not favored in the lottery. As I understand that the CMD authorities has a provision for allocate a plot in the above project for all those persons who are affected during acquisition of land of the project, I therefore pray to your good self to allocate me a plot of land for which I shall remain ever grateful, Lordship.
As I understand. So where from you have understood? Madam, what is the basis of your application? That must be.
Lordship, I have seen that my co-sharer who was in a similar circumstances, he or she was allotted a land. And there was, and now, Lordship, what they are.
Their affidavit in opposition, they have agreed to your contention.
No, what they are saying, Lordship will firstly see the first Lordship order before this Lordship Honorable Court.
Madam, try to understand.
Now, Lordship.
Since you are the read petitioner.
Yes, Lordship.
There's like a plenty. Carriage of proceeding is upon you.
Of course.
You have to show that this is the rule, this is the scheme, and the authority has violated the rule of the scheme.
True, Lordship.
So
I do
place
not
there.
have, Lordship, any papers regarding the scheme. It is true, Lordship. If they have,
let you consider.
There is no scope.
No, but Lordship, kindly sees
I will take 5 minutes. Let her
Yes.
finish.
First, when this writ petition was moved, Lordship, way back in 2015, Lordship kindly sees their stand. Lordship will kindly come to order dated 23rd of September 2015, Lordship. Here, Lordship, the second paragraph. The KMDA says that since the number of plots allotted for rehabilitation was much lower than the number of land losers, a lottery was conducted at the relevant time and the predecessor in interest of the petitioner was not successful thereat. So that was their stand. So it was not their stand that there does not exist any scheme like that. Now, Lordship will also kindly consider paragraph 15 of my writ petition. That is at page 13, Lordship. Your petitioner further states.
Give me a second. Page number
13 of the writ petition, Lordship.
13.
13. Paragraph 15. Your petitioner further states that it is pertinent to mention here that Srimati Pushpa Chaudhary and her son and legal heir Subrata Chaudhary already obtained jointly the requisite land as co-sharer and land loser in block number such and such. The deed was registered on such and such. Srimati Pushpa Chaudhary.
I'm sorry, you're reading from which paragraph? I'm not getting.
15, page 13 of my writ petition.
Oh, I'm sorry, I'm at page number 12. I'm sorry. Page number 13.
Paragraph 15.
Yes. Will you please once again?
Your petitioner further states that it is pertinent to mention here that Srimati Pushpa Chaudhary and her son and legal heir Sri Subrata Chaudhary already obtained jointly the requisite land as co-sharer and land loser in such and such. The deed of the said plot was registered on such and such. Srimati Pushpa Chaudhary, widow of late such and such, happens to be a co-sharer of the total plot of land in question acquisition by the KMDA through the additional land acquisition officer 24 Parganas South. So, Lordship, now we'll kindly see the opposition filed by the KMDA, Lordship, in connection with this paragraph. That is at page 5, paragraph 7. With reference to the allegations made in paragraph 10, 11, 13, 12, 13, 14, 15. So 15 is covered. I deny and dispute each and every one of them, which are matters of record, and I repeat and reiterate all these statements made in the proceeding paragraph 4A to E of this affidavit. I further state that the said land in RS such and such was fully acquired for public purposes, that is housing and allied purposes, along with many land in connection with LAKs being such and such. Possession was taken and made over to the answering respondent authority being the KMD on such and such. The said proceeding was duly completed and concluded by declaring award. One Horendra Kumar Chaudhary, the predecessor interest of the present petitioner, was awardee under the award serial number 173 and 191, respectively, and compensation amount was duly paid to them in respect of their land. On a reference being made, the award amount was enhanced by the learned court below, and the enhanced decretal amount was also paid to the predecessor in interest of the petitioner. Therefore, the predecessor in interest of the present petitioner was recognized as a land loser, but the same does not entitle him or her for an allotment of an alternative land from KMD. But Lordship, they say nothing about any lottery here. I say that the document being dated 18/12/2000 as annexed in page 54 of the writ petition does not and cannot confer any right to the petitioner or his predecessor in interest to claim an alternative land from KMDA, as the said document merely records the name of the land loser who have prayed for allotment of alternative land. Lordship, I am coming to this page. Some other internal correspondence do not suggest that the authority has decided to allot an alternative plot of land in favor of the petitioner or his predecessor in interest. The respondent authority did not never assure or promise and offer an allotment of an alternative land to the predecessor in interest of the petitioner, far less the petitioner hearing. I now, Lordship, categorically he has stated about paragraph 15. I dispute the alleged contention contained in paragraph 15 of the writ petition and say that no document has been annexed to prove that such contention to show that the petitioner or your predecessor in interest is similarly situated and deserve to be treated equally. So here, Lordship, their contention is that we are not in the same Lordship stand. It is also not their case that I am not even entitled to, or there was no allotment, or there was
Try
no
to understand. Firstly, you have failed to show any scheme or rule. Secondly, in their document, listen to me. In their document, in the document copy of the lease deed, I have gone through the recital. There is no averment that the lease deed was executed in lieu of the compensation. So how do you establish your case?
Lordship, allotment was made. Lordship will kindly come to page 54 then.
Maybe on account of some other consideration.
Lordship kindly comes to page 54 of my writ petition.
There must be some rule, madam.
Lordship, this is done by the Deputy Director M&M Unit CMD. Sir, I am directed to inform that the following information received from the land losers as required by you, vide letter number such and such, for your perusal and necessary action. Regarding para 2 of your letter, it may be stated that it was decided earlier that the names of the allottees and the size of plots to be allotted shall be decided by land sale vide notes and orders such and such of Srimati Biddeshwari Chaudhary. This Biddeshwari Chaudhary is the wife of Horendra Chaudhary. All these cases related to land losers of BPAD project. So, Lordship, the subject was allotment of plot.
So Horendra's wife got the land?
No. No, my mother, we did not get. First, my father pursued, he died. After that, my mother pursued. So, our name were recorded. We were to be allotted lands. Lordship, there are so many correspondence, Lordship, from...
No. In absence of any rule, how can a court can give you relief, madam?
Lordship kindly directs them to produce the scheme. It is their scheme, Lordship. I, being Lordship a layman, may not have the Lordship all the documents. But that doesn't mean, Lordship, that my valuable right...
Court will make out a case for you.
No. But Lordship, this is a
The
scheme.
court will make out a case for you.
It's not.
First, discharge your application first.
No, I have Lordship. Prima
Mr.
facie.
Talukdar, what have you got to say? I understand.
My lord, let me finish the paragraph he started to read. One more paragraph she has left. My lord, she read up to the second last paragraph. I dispute the LS contention contained in paragraph 15 of the writ petition and say that no document has been annexed to prove such contention and to show that the petitioner or his predecessor interest is similarly situated and deserves to be treated equally. This is the contention in respect of which that some other co-sharer has been given allotment, and thereafter she has not read. My lord, I am reading this. The veracity of such a purported claim of the petitioner could not be verified from the office records of the answering respondents authority. I therefore would like to put the petitioner to the strict proof of such allegation. We don't have any such record that in lieu of acquisition we have allotted that to anybody. Then I also say that the LS contention made in the referred paragraph 18 to 20, relying on the internal correspondence. There were some correspondence I will explain to your lordship. Internal correspondences of the answering respondent authority cannot come to the aid of the petitioner in any manner whatsoever, inasmuch as from those correspondences it can neither be inferred even that the respondent authority had ever decided to offer allotment of alternative plot of land to the petitioner or has made any promise to the petitioner to allot any such alternative land. The authority, being the requiring body, had in fact no scope to do so in absence of any such provision under the law. Come. Here, my lord, one thing here.
I'm dismissing, sir.
Not only he has accepted the award awarded by the collector, made a reference, and amount was enhanced.
Very good.
Enhanced amount.
Take your seat, sir.
My lord, I'm sorry.
61, I am appearing for the private respondents, my lords. So the petitioner is perhaps not willing to proceed.
My time for the petitioner, my lord, deadline is a Patroti.
My lord, wait, wait, wait.
My lord, can you consider the order passed on 13th February 2025? That matter of.
Oh, is that matter?
CID.
I have filed the report after order of.
এটা খুলুন তো ভাই। You are referring to which order, sir?
13 to 2025, by which, my lord, this CID investigation was directed by.
Give me a second. Let me go through it.
Okay.
Yes.
Now the report is with your worship, my lord. What is the report, my lord?
Before opening the report, I intend to know what is your prayer.
My lord, great.
My lord, my lord will consider the order first.
The prayers are at page 22.
Take your seat, sir.
13 February 2025.
No, what is your prayer in the writ petition?
My lord will find that Assistant Secretary Government of West Bengal, my lord issued
No,
one-
place the prayer first.
My lord, at page 22, my lord will find it.
I'm there.
A writ of annulment is the nature of mandamus directing the respondent number 3 to take appropriate steps and actions by passing necessary order, my lord, upon the respondent number 3 and 5 in order to arrive at a logical conclusion. So far, the grievances of the petitioners are concerned pursuant to issuance of the letter being such and such dated 2nd May 2024 without any further delay. Therefore, my
What
lord,
is this?
my lord, can you come to that, my lord? Exactly for one thing, since Mr. Roy is a
Very good.
My lord, and I'd like to point out, my lord, I am at the facing end of this order. So this order is prejudicing me because this
Let me
event,
see the report once.
my lord,
একবার দেখি।
because
এই দেখুন।
this,
বলরাম বাবু,
this investigation by the CID is violates my Article 20 because there is an FIR on the subject matter. This
absolutely.
would have been done.
Report
And the court was
already
Yes.
PAPS case has been started.
cross cases. I have filed a case, they have filed a case.
You are
Those
the respondent number 8.
6, 7, and 8. And
You are 6, 7.
8, all.
8 is your vendor. 8 is the vendor.
8 is the vendor. Like
6,
from 8,
7 is the purchaser.
my lord,
His grievance is that the lady was alive.
my lord.
And you posed the lady as dead person. You executed the deed of conveyance.
No,
By showing the
No.
legal layers of the
they,
petitioner.
Lord, may I just indicate that is not,
Be that as it may.
that is
So
not,
over which criminal case is pending.
my lord.
Civil suit is pending.
Lord, the facts as recorded, Lord, this fact,
Challenged by law, by my
Lord-
learned friends, client by law.
Lord, the facts, Lord, because it orders that the observations are preemptory. And I am pointing out that from the pleadings of the case, the facts as it appears from the order.
Not the
are
actual
contrary.
control of ATO FIR case as assumed by CID for a PS. So it has been taken over by CID.
Yes, my lord, CID taken the report, my lord, if you lordship will see the report.
No. Clause 11 is very clear. To honor the actual facts,
Yes, ma'am.
the control of investigation of Farakka PS such and such has been assumed by CID. So case has been started.
Case was pending at the time of moving of this
That
application.
I've seen.
And my lord, may I indicate just a few things which are appearing in the order. If your lordship takes-
Mr. They do one thing. Start copies of the report to them.
Yes, my lord, already the case started, my lord, to send the matter to the.
Case was already started.
That was, my lord, if your lordship will come next portion, subsequently court complaint, that is 10, my lord.
That is my
Admit down. Subsequently, court complaint under section 156(3) of the CRPC by CR number author filed by Srimati Moushumi Rai against the accused Srimati Shashwati Das and others before the court of London ACJ, Jongipur and Atho. The said complaint was dismissed by the London court. After that, my lord, to unearth the actual fact, the control of investigation of Atho has been assumed of CID to Atho to remain West Bengal detailed investigation. A prayer has also been submitted before the trial court to reopen the investigation of the case, my lord. And landed court has been pleased to allow the prayer and investigation case is prosecuted. Then, my lord, the case which was, my lord, that is dismissed, my lord, that was reopened. That case will be start, my lord, by the CID.
And that is
Already start.
Let us have a
Yeah.
copy of this.
Yes.
Report,
Likhun. The report of the CID as
They are going, it is not possible for them to pass any further order as because the case is pending before the Honorable High Court, my lord. Only for that reason, my lord. CID only, my lord,
Very
prayed
good.
for
liberty is given to the CID authority to proceed with
Yeah, please.
For the petitioner.
Lord, on last occasion, it was directed upon the state to file an affidavit in opposition. Lord, we have just now received the affidavit in opposition.
the affidavit in opposition as filed today. On
Right. For the petitioner, my lord.
Mr. Soumitra Bandyopadhyay, Ms. Suchana Banerjee, and Mr. Potopal. Where are they? Readings are complete.
They have given us affidavit in opposition, but we don't want to give any affidavit in reply because they have admitted the fact that they have acquired the property. In the affidavit in opposition, they have themselves admitted it, and they have also said that in page number 6 of their affidavit in opposition that they have deposited the compensation money with the land acquisition department. So, my lord, my request is that land acquisition department be added as a party.
Mr. Potopal has come. Where is your affidavit in opposition?
It is ready.
Yes, which paragraph is relevant, madam?
Kindly refer to page number 4, paragraph number 9, subclause 2.
Then,
upon detailed verification of the subject plot referred to in said writ petition, it has been ascertained that only RS plot number 1254 and 1261, Moja Kumirmari, jail number 60, block Goshaba in the district of South 24 Parganas falls within the acquired area of LA case number 411 of 2012 to 2013 at sheet number 14, which have been acquired along with other plots for the purpose of construction of ILA affected embankments at Sundarban area. And page number 6, my lords, subclause 6. Kindly refer to page number 6, my lord. The possession of the subject plots, being plot number 1254 and 1261, along with other plots, have been handed over to the Irrigation and Waterways Department by the Land Acquisition Collector, South 24 Parganas on 24/4/2023. Irrigation and Waterways Department, Government of West Bengal, being the requiring body, has deposited the compensation money with the Land Acquisition Authority. Now, whether the petitioners and or their legal heirs have received the compensation money for the subject plots, the Irrigation and Waterways Department has no knowledge at the present moment. Since information relating to payment of compensation, this department has no access. So, my lord,
so what do you want?
I request the Land Acquisition Department be added as a party. And my lord,
Special land acquisition officer has not been made party.
no, my lord.
He is the necessary party. Land acquisition officer is the necessary party.
Special land acquisition, this is South 24 Pargana.
Yes. Yes.
My lord, I crave leave to produce one supplementary affidavit also. Some facts has come before me afterwards. I have submitted them the copy also.
After filing of the affidavit in opposition, how can I allow you to file supplementary affidavit? If it is you, if it is required, I can consider.
Okay, my lord. I have given one.
My application. Kindly have a look at the.
So the state.
Actually, Mr. R.N. Datta was supposed to appear for state. He has not come today, so I'm praying for not today.
Not this week. Devi Prasad Ghosh. Mr. Anjan Kumar.
Matter.
Huh?
Matter, in spite of the order of the court, possession has still yet not been handed over.
I mean, not this week, Mr. Pan. He has not come. He is under a. Without him, I could.
Last occasion, so they did not appear.
Very good.
Not item 67.
I am for the petition.
I am for the respondents. But only one difficulties matter is otherwise ready. I am also ready. But the problem is the affidavit in opposition was lying with Mr. Bhaskar Mitto, who was the senior at the relevant point of time, that he has died. Problem is, Milord, the original affidavit in opposition, Milord, I could not find out. If your lordship's Milord copy is here with us.
So reaffirm and file.
Yes, it was exchanged also. So, Milord.
Affidavit in reply, and when I seek to file one supplementary affidavit, Milord, this is regarding a subsequent event, Milord. Disciplinary proceeding, Milord, he was terminated. On the ground, Milord, alleged misconduct, Milord, allegation of bribery given by Milord, somebody who was ultimately not examined. Criminal proceeding conducted, ultimately in the criminal proceeding, honorably acquitted. That judgment, Milord, which is very relevant because Milord, honorable acquittal, Milord, gives Milord, complete, Milord, separate connotation to the entire story. Milord, I want to rely on and Milord, use the judgment as a supplementary affidavit, Milord, on the criminal court. Kindly permits me, Milord, to file it. And this is the affidavit in reply.
The affidavit don't file. Let them file the affidavit in opposition.
Yes.
They have to reaffirm.
Reaffirm.
They will. The same
When it will be done?
Within 7 days. Because affidavit is ready, we only reaffirm it.
Asun.
And file.
May I only pray this, Milord? They kindly not fix a date because the person not.
Yes, yes,
No retirement.
any day your lordship fixed, I don't
He
mind.
was an employee of
WBSCDCL. He was our employee
Is that? Yes.
at the raid program. He was caught red-handed. So that's a different, but that's the main merits of the case.
Terminated without any benefit, Milord. Suffering a lot, kindly.
No, not any benefit.
On behalf of the
might say,
evidence. My lord, the criminal proceeding, departmental proceeding is completely different. Your lordship knows everything.
if they want to, kindly allow me to
Yes,
submit.
yes.
If they want to use any opposition or reply opposition to this, Lord, let them do it in the meantime. On that day, they say no supplementary contains substantial allegation. I'll use a affidavit. Let that not be the case. If he wants to use,
The appellate authority, my lord, didn't occasion to consider the
একটা লাইন লিখে নিন
consider the my
satisfaction
lord.
of Mr. Banerjee. Mr. Cole submits before
then let him make the prayer. Let the prayer not be made on that day.
further liberty is given to the respondent WBSCDCL
My lord.
to use exception to the
My
supplementary
lord.
affidavit as filed by the petitioner today. Happy?
Grateful to your lordship.
Happy?
Yes, yes. Otherwise, although your lordship knows, my lord, the criminal proceedings acquittal, my lord, does not bear with the departmental proceedings. Clear.
I shall consider.
Yes, yes. Your lordship had already considered certain matters.
Many matters.
I have occasion to appear at least 2-3 matters, and your lordship already was done.
The advantage of what is can one?
And one, this has been disposed of because restoration application long. Now, you lordship kindly see the order dated 23rd February 2024.
23rd February or March?
March 24.
Give me a second. Where is Mr. Mahata?
Long pending matter.
Serve a notice. Null appears for the state.
Lordship, I am for the
My lord, I am
State-
appearing for the Siliguri Jalpaiguri Development Authority, added respondent number 4.
Lordship,
Ready?
Lordship, I am appearing on behalf of the state respondent, Lordship. Lordship, kindly extend time for filing opposition, Lordship. Affidavit in opposition ready, but only affirmation portion, Lordship. Only give me a 7 days time, Lordship.
Copy, sir. Affirmation is not been completed.
Lordship. Only 7 days, Lordship.
Your Madam Shashwati Chatterjee.
Lordship.
Ashun. Ms. Chatterjee. Huh? What are those cans?
One can is for addition of party, substitution application.
First
That should have been disposed of.
Lordship.
Those are disposed of.
Both can. দুটোই dispose of
There is one section 5 application and one
and substitution
substitution application.
Can you tell me when it was disposed of?
Lordship.
বলে দিচ্ছি 24 না আরেকটু আরো আগে 24
Can 1 and can 3. কোনগুলো দেখাচ্ছে গো?
Can 2.
Can 1 and can 3. Can খুঁজে পেয়েছো গো?
Injunction application. একটা injunction ওই করে নিচ্ছি একটা substitution আর তারপরে section 5
সঙ্গে তো হয়ে গেছে
110663. এটা হচ্ছে can 3. Wait for a second, ma'am.
Lordship. আমার প্রিফারেন্স সব ছিল জয়েন্ট আমার থেকে সব নিয়ে না যাতে হারিয়ে গেছিল বলে নিল আজকে আনেই উনি
Can 1 of 2010. What is that?
One can injunction application, another substitution along with section 5. হয়ে গেছে সেটাই তো বলছেন ডিসপোজ অফ হয়েছে কিনা
না এটা হচ্ছে তোমার 15 পুরো
না 15 ওটাই তো আপনার সাবস্টিটিউশন
পরে
It aside the publishing award in respect of your petitioners. না এটা তো অন্য জিনিস আছে Can 4 is an application for substitution. এটা শো করছে না Can 3 is different. Can 5 is an application for section 5. And can 6 হচ্ছে abatement of setting aside abatement. এগুলো কিন্তু থাকবে জানেন কল্যাণবাবু এটা কিন্তু ক্যান 1 of 2010 টা আমি দেখতে পাচ্ছি না। Have you any copy of CAN 1 of 2021? You don't have the brief also. যা আছে থাক, সেদিনকে দেখে নাও। একটা লাইন, just add one line. Since CAN 1 of 2010, other side, sir.
AM Hussain. AM Hussain.
দেখি দাও দাও ফাইল দাও। KM Hussain. Epidemic in opposition state not ready. আজকে এলো না। Not this week, survey notice. Survey notice. What can be done? Mr. Bhattacharya, nobody is here interested in hearing, but I'm telling you.
And mentioning will go on.
Huh.
Pressurizing the court. Have the matter listed, please. Heaven will fall. And once the matter is listed, no one is interested. Very unfortunate.
I'm here from right 2 p.m. I can dispose of only one matter. Because of either this side is taking time or that side is taking time. মামলা ডিসমিস করতে শুরু করতে হবে, নাহলে
I'm
হবে
for
না।
the petition, Your Lordship.
I'm for the respondent.
It's time to file my affidavit in reply.
Why?
They,
Why it is not ready?
Your Lordship, they were out of time, Your Lordship. They have on
Oh, my
4 occasions have paid time to file affidavit in opposition. They,
You will take 8 weeks.
no, 2 weeks, Your Lordship. 2 weeks. They were out of time.
My lord, I have filed within time, my lord.
Your Lordship,
As per the last
2
direction, my lord,
weeks
to
only
within
take
2 weeks,
them.
26 June, I have affirmed and
My learned
served
was
copy.
not served within 2 weeks.
I served on through email. Thereafter, my hard copy was
Hard
sent.
copy was served on us on
Sent
7
through
2025.
email.
On last 4 occasions also they have time to file affidavit in opposition. First time I am seeking time, 2 weeks time to file.
But I am
Well,
fine.
can be able to consider. Take it in.
Composite paragraph.
Why not do? Why don't you serve the copy in
My lord,
advance?
serve within time, my lord. I have mailed him, mailed her, and my lord, the hard copy will be served thereafter, my lord.
The composite affidavit in opposition as filed by the Mr. Bhattacharya is in read matter. Criminal division matter.
Seeking quashing.
Read.
Lordship, Mrs. Chandra Yalam is appearing on behalf of the respondent. Her husband has been passed away on 13 July.
It's a very
Praying for not this week.
So, my lord, can I request for any date that's convenient to your lordship?
Then month list of July. Next month, August.
Come.
On behalf of the respondent Union of India.
Yes, Union of
And accommodation has been paid for. Prayer for accommodation has been many courts are there.
Well, the difficulty is only one antecedent bail court, but the bail matters are bifurcated amongst three honorable judges. But one court having fresh motion matters and antecedent bail matters. It's very heavy bench, my lord. That's the difficulty. Single bench, my lord. Justice Joyshan Gupta. No, my motion bench, your lordship is aware of, it's extremely busy court. Now again, all antecedent bail matters. I don't know, my lord, when bail matters are bifurcated, my lord, that there will be, my lord, NDPS court. I mean, NDPS matters taken up by one honorable judge, then, my lord, POXO, then the residuary. Then there can be, my lord, I mean, antecedent bail matters as well as motions could have been distributed like that. But in all other high courts, this is the practice. Fresh matters. Well, the persons who are the portfolio holders, they don't do anything. That's the difficulty. I told them many a times, my lord. Because one honorable judge, kindly appreciate, my lord, the honorable judge who is taking up that determination is under extreme pressure, my lord. Look, fresh matter, Justice Sengupta, then Justice Bivas Ranjandi is having 2024 matter, now recently given to him. Earlier, his lordship had the only old matters, and Justice Mukherjee is having few fresh. No, but I am, your lordship knows, almost jobless.
Your other side is here?
Yes.
Very good.
But the private respondent is not present. I think his appointment is under challenge.
Huh?
Appointment of respondent number 6 is under challenge. Matter was dismissed on merit.
Moving against the private respondent, I am praying for recalling of your lordship's order, which was passed in the absence of the petitioner on merit. Lordship generally does not do that. It should be dismissed for default. But lordship has passed the order on merit, my lord. So we have come out with an application for recalling of the said orders. Yes, sir.
So how can I recall this matter? I have disposed it on merit.
Recalling application in the view of the fact, my lord, the order was passed by lordship on merit in the absence of the petitioner.
So you prepare an appeal. Not permissible. This is not permissible, sir.
I have approached your lordship, my lord, probably lordship.
No, it cannot be done. It has been disposed of on merit.
On merit ex parte.
Be that as it may. Asun, Can 1 of 2025.
I appear for the respondent KMD. Huh? Oh, sorry, next item. 76 bole na?
None appears on behalf of the writ petitioner.
Oh, Lordship, Mr. Depending that is appearing, Lordship is coming, is on his leg, Lordship. I'm praying short pass over.
At this hour, short pass.
Not today. From the month of August, praying for Passover will be treated as a prayer for seeking a dismissal. Yes. This thing cannot proceed. Hearing matters. Nobody is taking absolutely disgusting, sir.
78, I am appearing for the petitioner. The matter relates to an appointment of approval.
Who is the other side? The file.
Yes, other side, I have already given a notice in 2021.
No,
Now,
we press notice.
The Lordship
Let the matter, the state respondent state is not represented. Let the matter be listed in. $79. The parties are not represented.
Well, only one thing is that on the last occasion, the state government, they filed their affidavit in opposition and time was granted to me, I am the petitioner, to file our affidavit in reply. Well, our filing the affidavit in reply to the affidavit in opposition filed by respondent numbers 2 to 5 as per the order passed earlier, my lord. Affidavit in opposition file is the
Affidavit in opposition file?
Yes, madam. On 4th May, affidavit in opposition file in the
Not
department.
two at a time, madam.
They said that the affidavit in opposition has been filed in the department. So, well, I don't know whether it has come in the court file. It was filed in the department. To dekhen inna bhai, jota ache kina. অপোজিশনটা দাও তো কই পয়েন্ট নাম্বার 225 এর অ্যাফিডেভিট ইন অপোজিশনটা দাও আমাকে ও পেয়েছি এখানে আছে
This is the affidavit in reply of the against the epidemiologist respondent number 225.
225 my lord.
How many respondents are there?
এই পিটিশনটা দাও রিট পিটিশনটা
Huh?
ওদিকে যাও রিট পিটিশনটা দাও because seven respondents are there. Already the other respondents, they have used the affidavit in opposition. Miller, 7 total respondents, and amongst those, Miller, the others have filed their opposition, the respondent number 1, respondent number 6 and 7 all, but the 2 to 5 were left. So now they have filed their opposition, that's true in the department. So, Miller, সবকটা affidavit in opposition reply দাও একসাথে হাতে এটা তো একটা হলো
ঠিক বললেন বাবু এটা একটু কার্টুন ভাই আমি বুঝতে পারছি না এটা কেটে এটা খুলে দিন না খুলে দিন
opposition আর reply দাও একটা করে হ্যাঁ এটা হচ্ছে কার এটা হচ্ছে 6 এর রিপ্লাইটা দাও ঠিক আছে একটা করে বার করো না তারপরে আবার ওটা কোত্থেকে ওটা হারাবে opposition তাহলে রিপ্লাইটা দাও লিখে নাও আমার কি পেনটা দাও করে না এটা রেসপন্ড নাম্বার 1 দাও oppositionটা ওয়ানটা কমপ্লিট করো দুটো ফাইল মিলিয়ে দেখো
Madam, how many affidavit in reply you have filed? 3.
Yes, there are so many affidavits in opposition from time to
Very
time.
good. How many affidavit in reply you have filed? That I intend to know.
Miller reply respondent number 6, respondent number 1, and respondent numbers 2 to 5. Now, Miller, I am searching whether any affidavit in opposition was filed by the added respondent number 7. দেখো তো respondent number 7 কিছু দিয়েছে কিনা?
You are appearing on behalf of?
Respondent 1.
One affidavit in opposition reply, both has been completed. Now 6 opposition and reply has been complete. 2 to 5 complete. Whether the added respondent number 7 that we are
Respondent number 1. এটা গেল একটা
1 হলো দেখো তো 7 কিছু দিয়েছে কিনা? Right. 7 has not used any affidavit in opposition perhaps.
এইটা হচ্ছে
1 6 এটা হলো 1 6
কি Mr. Chatterjee?
Chatterjee said the report. We have forgotten this when our.
Who kept this?
Huh?
Who kept this here? Who had left this?
Actually, I also have forgotten. It's also my cooking.
No, you ask your senior to collect.
Miller, I found that 2 replies and 2 oppositions for respondent number 1 and 1 opposition and reply for respondent number
What is the affidavit in opposition of 2 to 5?
2 to 5 they said that they have filed it in the department. So whether that has been come in the court file that they do not know. They filed in the department. Respondent number 1 এর তো তুমি কি respondent number 1 দুবার করে opposition হয়েছে
Which for the respondent number 2 to 5?
2 to 5.
জওয়াহরলাল নেহরু কোথায় রিয়াফর্ম কোনটা হয়েছে দেখি
এই উকিল ওকেটা দাও
I look the department my love 4th May
Read this order. Order dated 27th February.
2nd August 2024 29th August 2024 18 November 2024 Respondent number 1 না এটা 225 রেসপন্ডেন্ট নাম আমার শুধু তো মানে মামলা করবো কি মাথা গুলিয়ে হয়ে যাচ্ছে তোমার এটা একটা দেখতে হবে
Take the microphone.
4th March it has been filed madam in the department my lord
Madam, read the order. Place the order as passed by me. Kindly place, madam. Place.
রিপ্লাই দিইনি তো এটা রিপ্লাই দিয়েছি কি আমরা
6 এ রিপ্লাই আছে
6 বাদ দাও 1 যে পরে আবার ফাইল করেছিল সেটা রিপ্লাই দিয়েছি রিপ্লাই তো অনেক আগে দিয়েছিলাম ডাইরেক্ট রিপ্লাই না না ওদের নতুন দিয়েছে অ্যাফিডেভিট এটা কপি দিয়েছো আমাদের কোথায় গো নতুনটার কপি দাওনি তো কপি না দিলে ওটা কি করে ফাইল করবে আচ্ছা তো এখন ডিসপ্লে নাম্বার 1 নিয়ে দেখি আমরা কপিটা কোথায় রিয়াফার্মে কি লিখেছো দেখি একবার প্রথম কটা কথার একটা দিয়ে দাও না আবার রিয়াফার্ম করছো কেন ফাইল লিখেছিল বলে
Have you complied with that order?
আমাকে একটু দিয়ে দাও
ডিপার্টমেন্ট মাইলা
দিয়ে দাও না
Madam,
ইয়েস মাইলা
kindly tell me whether you have complied with that order or not. Where is the affidavit of opposition?
I filed in the
Last paragraph, kindly read. Kindly read it loudly so that I can hear.
Let the matter be listed in the monthly
Prior to that.
in view of such further liberty to file their affidavit in opposition within 2 weeks hence.
Then where is that order? Where is the compliance of that order? You don't need not file. I'll decide the matter in the absence of the affidavit of opposition. Sorry.
But then will I have to take back the reply?
Yes, take back. You could have reaffirmed. I passed order in open court. Then you have not complied with.
So,
You will suffer the consequences.
My lordships, kindly record that the copy of opposition was served on us. That is why we prepared the reply and affirmed it as per my lord's order. So there is no fault on our part. Lordships, kindly record that the opposition.
Why are you so scared? If the affidavit in opposition of 225 is not filed, you proceed with the case. Place your case. If you take it so mechanically, madam, you will face the consequences.
Well, the petitioners before your lordships, they are working.
What are the answering respondents?
Well, the High Court, respondent number 1.
High Court administration is the
because they are working against the essential posts in Bijan Bhavan. The petitioners are the liftmen and the electricians and working in other capacities too in Bijan Bhavan.
What is your prayer?
Under direct capacity of.
What is your prayer?
Well, Lord, my prayer is appropriate wages and salaries as has been granted to the permanent electricians and liftmen because they are doing the same work. They are doing the same work. Only there is a contractor between, but contractor has been changed from time to time. That is admitted by the respondents. But the petitioners are same and tendering their service for last 20-25 years as liftman and electrician in Bijan Bhavan. While the permanent liftman and electrician, they are getting the great pay of the regular scale of pay. The petitioners are not a minimum allowance.
What is the mode of your entry?
My lord, mode of the entries, I'm telling my lord.
I believe you are a contractual employee, no?
My lord, in fact, what happened? My lord, contractor is likely a sham contractor because the contractor is changing from time to time. But the petitioners, they are working. Whoever contractor are coming, they are not really taking any role in the continuity of the petitioners. They are working since a pretty long time, my lord, in Bijan
So if
Bhavan.
your entry to the service
Yes, my lord.
is not at par with the other persons, How can you claim the equal emoluments,
Lord,
madam?
there are several judgments on these, that when we are doing the same work and when the work is essential in nature, that is really compulsory for running the institution properly, and they are taking part, then there is no reason that there is no sanction post or like this.
Very good.
Jaggo
Place your
judgment
case.
allow-
Place your case.
Yes, my lord. My lord, in fact, in Bijan Bhavan, there are quarters for the Honorable High Court judges, guest accommodation, paragraph 4, Judicial Academy, conference hall, etc. The petitioners are working and taking care of the entire Bijan Bhavan, including the quarters accommodation, and there is no permanent staff, either in the capacity of electrician, paragraph 4 of the writ petition, page 6.
Three, 4, 7, 0, 8. The 13.
বসো না, দাঁড়িয়ে আছো কেন? petition reply একটা করে দাও, এটা রাখো, এটা রাখো। কোনটার opposition? দুটো আছে opposition. Responding now.
You are Madam Sengupta?
Yes, my lord.
Yes, madam. Which paragraph, page number?
My lord, page number 6, paragraph 4.
Page number 6, paragraph 4.
My lord, in paragraph 2, we have started with the petitioners are working in different capacity, paragraph 2 at page 5 in Bijan Bhavan. Petitioner numbers 1 to 5.
Page number 6 or page number 5?
My lord, first page number 5, my lord. Paragraph 2.
Yes. Which paragraph, madam?
Paragraph 2.
Yes.
That the petitioners are working in different capacity. Petitioner numbers 1 to 5 are working as electrician, whereas the petitioner numbers 6 to 10 are working as liftman.
Yes.
Then below 3 petitioner numbers 1 to 5 have their license from the government of West Bengal to work as electricians, whereas the petitioner number 6 to 10 have got their license to work as liftman. All are license holders. Then below paragraph 4. The page 6. Well, it is pertinent to mention here that in Bijan Bhavan there are quarters for Honorable High Court judges, guest accommodation, Judicial Academy, conference hall. The petitioners are
No, Judicial Academy has been shifted.
Has been now. But when they are working, there was Judicial Academy and also conference hall.
It was functioning at Bijan Bhavan.
Now, Justice, kindly find this, that the petitioner is working and there is no permanent staff, either in the capacity of electrician or in the capacity of liftman in the said Bijan Bhavan. In fact, the Bijan Bhavan is an extended part of the Honorable High Court at Calcutta. Yes. Now, where from they have come? Paragraph 5, that the petitioners are working under the supervision of contractors as deputed by the Public Works Department Electrical Division under the instructions of Honorable High Court at Calcutta. The petitioners have been working since last 12 to 10 years, that is of 2013. Now it has become 25 to 26 years. Uninterruptedly and irrespective of change of contractors, they are working. Earlier, the petitioners were working under Usha India Industries Private
So you are in the payroll of PWD?
No.
Then who give you the salary?
Below the salary is being paid by the contractor, and contractor there has been when the change of contractor, the new contractor has been paying. So there is no system that they are not contractor workers. Then with the change of contractor, the petitioners will go out. The new persons under the new contractor will come in. But that is not being done in this case. Irrespective of change of contractors, the petitioners are contracting, working. The
The petitioners are in the payroll of the contractor.
not payroll, they are not contractor workers, but they are being paid through contractor. Well, this is a fishy system is going on. They are not in the payroll of the contractor. They are not the contractor workers. Then with the change of contractors, the petitioners would have been changed. Process kindly consider if they are in the payroll of the contractor, if they are the contractor's workers, then what happens when a contractor is going out? Their workers, their paid role worker persons, they will also go out with the contractor. And what the contractor will get the assigned with the new job, they are their own
No,
persons will
it
work.
may so happen that out of compassion, the new contractor decides to employ you.
No, the new contractor is only a name lender. That is also.
Then who pays your salary? PWD or High Court?
High Court, my lord.
Huh?
High Court. My lord, High Court sponsored the fund. That is made in the affidavit in opposition of the respondent numbers 2 to 5, that the High Court has sponsored the fund. Lordships, they have filed. They said that they have filed in the department. Lordships, kindly take my copy. That is why it is very vital. They said that under the public work system of the government of West Bengal, the contractors were selected through tender process by the public works department, and tender agreements were entered into by this department and contractor to have the allotted work done. The Honorable High Court Calcutta sponsored the fund. Only at the disposal of this department.
High Court
sponsored
Calcutta
the fund
sponsored the fund to the contractor.
to the public works department.
Public works
Yeah.
department.
So the
Public works department pay to the contractor.
and contractor pay to them. So, my lord, the main employer is the High Court, who is paying the fund. Everything is done so as to deprive them from a regular engagement, in spite of the fact that the work is perennial and essential in nature. Well, a recent judgment, the Honorable Supreme.
No, then who is your employer then?
High Court, my lord, who is making the payment? It is the.
So show your appointment letter issued by the High Court.
No, High Court did not issue. That is the.
How can you claim that you are an employee of the High Court?
My lord, this is an eyewash, because High Court has sponsored the fund. High Court has directed the public PWD to take the persons.
How can you say that High Court has made an eyewash? High Court administration, I believe.
I cannot say that. Yes, I am not saying that. I cannot say that. I should
No,
keep it
if
in my
you
mind.
claim that you are an employee of the High Court, there must be an appointment letter.
My lord,
What document you have relied upon to substantiate that you are an employee, even a contractual or temporary employee of the High Court?
My lord, I am showing, my lord. I am showing, my lord.
You, my lord.
52.
But I left my iPad in the first half.
Yes.
Doing the math.
We are already eagerly waiting for you. One of your junior or intern has come. So yes, he's here. I asked your. Kindly check it whether it is yours or not. Or otherwise,
Doctor has got it.
another is available here also.
ছাড়ো তো, পড়াশোনা করো না, হঠাৎ করে এসে ঝাঁপিয়ে পড়ে সব ঢুকে পড়ছে। Yes, lordships.
Take your seat, Mr. Madam, take your seat.
ছেড়ে দাও এটা, ছেড়ে দাও।
এটা আমাদের রিট পিটিশনটা তো। In fact, they have given the identity cards, no engagement letter as such. They have given the identity cards.
Naturally, when you are working as in the High Court premises, there must be an identity card.
Identity
The
card.
identity card does not create any
But below identity card.
No, if you are, madam, if you are paid by your contractor, how can you claim the regular
My lord,
pay scale? I fail to
contractor
understand.
is an intermediary created for the purpose so that the petitioners cannot claim their permanent status or regular pay. Because High Court sponsors the fund, for the Bijan Bhavan is a part of High Court. That is the.
It's like a outsourcing, madam.
My lord,
It's like an outsourcing. How can you claim?
Where from the money comes? Well, everything is regarding that who is really responsible for this. She is making the payment. Here, when the High Court is sponsoring the fund,
Madam,
that comes through
I'm very
PWD.
specific.
Yes, my lord.
What documents you are relying upon
Yes, my
to establish that there exists a relationship between the writ petitioners and the High Court administration, that there exists a relationship of employer-employee between the High Court administration and the writ petitioner.
Yes, my lord.
Where from you will get that?
From their affidavit in opposition of the respondent number 225, the state government, they have said that. They have said it. They have admitted it.
High Court has been admitted.
High Court ta koto number? Respondent number 1 to.
I'm respondent number 1. High Court is respondent number 1.
You are the High Court.
And respondent numbers 2 to 5 is the government, PWD department. Respondent numbers 2 to 5 is the governmental authorities.
You don't have a good case, I believe. You don't have a good case, I believe.
My lord, let me make my argument. Thereafter, to my lord will decide it. I shall try to.
So prima facie, I am not satisfied with your contention. You could not reply to my answer. I want to know who is your employer. You said the High Court is the ostensible owner, employer. For the sake of argument, if I accept, then what documents you are placing to substantiate that the High Court is the ostensible employer? That's satisfied.
I am showing.
Please.
Lord, then lordships, respondent number 1 is High Court.
Yes.
Respondent numbers 2 to 5 are the PWD department, and respondent number 6 was the erstwhile contractor. Respondent number 7 was added as the present contractor. Lordship wants to know that which document, any engagement letter or any certificate from the High Court. Respondent number 1 is affidavit in opposition. Respondent number 1 is
the person who has affirmed the affidavit. The person who affirmed the affidavit in opposition of the High Court administration has now become the Honorable Judge of the High Court.
Well, it's difficult for my lord also, I understand. This is. Nah, reply in opposition. My lord, lordship, I am just praying for one thing. Lordship, kindly, my lord, direct them to file the opposition. I shall file my.
No, you place your case. Forget about their opposition. Your strategy is like a plaintiff. Carry your proceedings are with you.
The onus of proof is on me.
Absolutely. Carry your proceeding. Forget about the onus of proof. There is a concept of evidence act. Am I correct, Mr. Dhar? Burden of proof and onus of proof are those are concept of evidence act.
Well, one thing I have candid on that there is no engagement letter for the petitioners. No, I am showing from the circumstantial facts. Thereafter, it's up to my lord.
Yes.
Then, my lord, this is in reply to my lord's first query that there is no such engagement letter issued by the High Court at Calcutta. But from the facts, I am submitting that High Court is the employer, ultimate employer. That is why my lord said that High Court has outsourced.
Madam, then what is the basis of your submission? Please satisfy.
Well, the fact that they are working for last 24, 25 years.
Madam, a person who is working.
Yes, my lord.
In the garden of the High Court, he does not necessarily become an employee of the High Court. Several police persons are guarding the High Court. Does it mean that they are working in the High Court premises, they have become the owner, employee of the High Court? They are under the police department.
My lord, the guards are the police guards under the really police department. But the persons who are taking care of the Bijon Bhavan, that is the lift man and the electrician, if they are through the contractor, my lord, then also, my lord, I'm just showing one judgment to my lord.
So what do I do with the judgment if you do not satisfy me on facts
No,
first?
point is that when my lord says that they are, though they are in essential and continuous service, even then they are not High Court staffs. So, my lord, High Court or PWD has nothing to do but to keep them in the payroll of the contractor at any cost which the contractors are paying, because the High Court is sponsoring the fund that comes through this PWD to the contractors. Then I am praying for an order upon the contractor, if my lord thinks so, that they are the persons of the contractors through the public service department, public works department, to give them equal pay, but they are doing the same work at an unequal payment order. They are doing the same work because there is no permanent staff. Even if it is outsourcing, there cannot be an illegality in payment. My lord, I am showing one judgment of Jaggo reported in 2024, Supreme.
Who is the respondent number 6? Is the contractor.
And he has been changed. Now this respondent number 7 is the new contractor.
Respondent number 6 he says that he has employed you people.
Respondent number 6 এর opposition টা
Page number 7, clause C.
Respondent number 6 এর opposition টা দাও। Respondent number 6 এর opposition টা
Take them. Yes, what judgment you want to see?
Yes, my lord. My lord, this is a judgment reported in 2025 AIC Jaggo versus Union of India. I am showing to my lord. My lord, paragraph judgment starting from paragraph 4, the appellants before this court, being applicant numbers 1, 2, 3, and 5 before the tribunal, were originally engaged by the Central Water Commission on part-time or ad hoc terms. Applicant number 1 was appointed as a Safai Wali in 19...
You are reading which paragraph?
Paragraph 4 of the judgment. Page 5, inner page 5. The appellants before this court, being applicant numbers 1, 2, 3, and 5, before the tribunal, were originally engaged by the Central Water Commission, in short CWC, on part-time ad hoc terms. Applicant number 1 was appointed as a Safai Wali in 1993. Applicant number 2, Safai Wali, all are the Safai Wali. All three were primarily responsible for cleaning and maintaining the office premises under the CWC. Applicant number 5 was appointed as a Khalashi, was entrusted with the task such as gardening, dusting, etc. Throughout their engagement, these individuals performed essential housekeeping and support functions at CWC establishments, including its offices at Faridabad, ensuring daily keeping and contributing the commissioner's administrative operations. Initially, the appellant sought regularization of their services by filing original application. They contended that over the years, their roles and responsibilities had evolved beyond the nominal levels of part-time or contractual, and that they were performing ongoing and core functioning integral to the CWC's operations. They relied on applicable government instructions and the principle that long-serving employees engaged against work of a perennial nature deserve fair consideration for regularization, provided their appointments were not illegal or clandestine. The tribunal dismissed the appellant's plea. It contended that the appellants were not engaged on what it considered regular vacancies, that they had not completed what is termed as sufficient full-time service, and their case did not attract the
But their
principals.
appointments were made by commission, madam. They distinguishable. Take down.
Well, let me complete it.
No, sir, madam. This is not at all applicable. Take down.
annexed with the reply that is signed by the Public Works Department.
ওই একটা জায়গায় বললাম না, except the attendance register, except the attendance register of the writ petitioners.
No, no, I'm sorry to, but my lord, before lordship take up the next matter, my lord, the previous matter, I was appearing on behalf of the petitioner, my lord was pleased to dismiss it for default.
I cannot, I never recall, sir.
In presence of other side.
You apply.
My lord.
You make an apply.
Restoration lago, ek pata.
Who's for the state?
See, earlier occasion never appear the respondent, state respondent lordship, before bench lordship, the Honorable Justice Bench, Pothik Prakash Banerjees never appear.
Have you served notice?
Served notice, lordship. Your lordship passed the order 20th March of 2025, then serves the other side, lordship.
Have you served to the learned GP?
GP lordship, the learned advocate Supriya Chatterjee appearing and Sabyasachi Mondal appearing, junior and senior advocate. Both appearing the state government lordship.
Then why are not they appearing?
Earlier occasion lordship are not appearing, then the contempt petition is filed, then the upon the state respondent, the cost imposed earlier court lordship. Petitioner is a lordship, the retired teacher is suffering from lordship, the 2013 lordship. This matter is pending since 2013.
So where is your writ petition? এই writ petitionটা কোথায় গো?
Writ petition lordship, the 36074 lordship 2013.
বলেন বাবু, where is the writ petition? Contempt has been disposed of.
Contempt disposal.
বলেন বাবু, writ petitionটা কোথায়? এইখানে এইটা? Oh, I've got it. Got it. Have they used any opposition?
No, lordship never filed any opposition. That's why lordship now filed on any reply.
DI is the answering respondent.
Answering respondent DI.
The affidavit of service as filed today
26, Lordship. The petitioner left for due to some medical emergency in his house, Lordship. Kindly, it has been dismissed for default, Lordship. I